Good. Good to see you. You got your stuff. You got everything else.
Yeah.
Loaded. Small town. Okay. And then somebody was asking that you guys go for the county. Is that okay with you?
It is.
Okay.
Yeah.
All right.
Is Sylvia here?
Back row, sitting next to
Oh, okay. Yes. All right. And as far as like affected party status, are okay. So like if we, I know that cross examination is technically allowed, but like
You're going to do that in your case. We're going to put up, Brian will get up and introduce the application. Michael will talk about the description.
Yeah.
And then the applicant will go on their case. And then the affected parties, the county. Brian will get back up, and after this last, presents your staff report recommendations, and y'all get to cross-examine. Yeah, all right.
Okay.
I'm just trying to keep it organized so the transcripts.
Sure. Is there a court reporter?
I thought I saw it right there.
Okay.
I'm guessing the applicant.
Yeah. Right here. All right. Sounds good.
Good. How are you?
No. Oh.
Ready? Good evening, everyone. We'll start the meeting here. Everyone, please stand for a moment of silence, followed by the Pledge of Allegiance. All right, just a few housekeeping notes. If you have a cell phone, please turn it on silent and take any calls outside. If you come up to speak at the appropriate time, come up to the microphone and speak clearly into the microphone. And for everyone here, please remember to turn your microphone on and speak clearly into the microphone. All right. Old business, the meeting minutes from, sorry, let's approve the agenda.
Mr. Chair,
Go ahead.
staff would like to request that we make a minor change to the agenda and that we move items C and D up ahead of item B. They're relatively small items, and the item C is likely to go very long. And so they're also old business. We'd like to move them up and let them go ahead and get that over first.
Okay, thank you. Board members, you okay with that?
So to clarify, I guess item C and D are moving ahead of item A and B.
That is the request, yes, sir.
I'll make a motion to accept the revision as requested.
Second.
It's been moved and seconded. Is there any public comment on this?
Good evening, Mr. Chair, board members, staff. My name is Tamara Robbins. Mr. Chair, I believe that it needs to be addressed that this room has been determined to be at capacity for an advertised public hearing for this application. And so there are many people waiting out in the lobby, and the city knew in advance, the city staff, administrators, knew there was a potential for an overflow need, and they didn't accommodate this potential. So I'm asking that you make a determination, because the police officer is saying that the doors back there actually need to be closed so the public can't even stand outside in the lobby and listen. So we need to know what the law is on allowing the public to participate in the accommodations that the city did or did not provide. So could we get clarification on whether is it legal for the public to stand in the lobby and listen? And the city did not provide an overflow, which I told you guys all about last night. So please make a determination, because the public is responding to this call to a public hearing and the door is being closed in their face. Thank you.
You? Any further comments?
Hello, Mr. Chair, board members. Since this is the adoption of the agenda, my comment is about the quasi-judicial item that is coming. I've been in about a dozen quasi-judicial hearings in this room, and when I was reviewing City Code 2.31D, order of proceedings for quasi-judicial hearings, I just want to state it for the record, because those who may be new here or not familiar with the code, what the order of that should be. I'll also give you a copy and leave some in the back. 1, swearing in. 2, ex parte disclosure. 3, description of proposal from staff. 4, applicant presentation. The applicant goes, then affected parties, then staff report, public comment, and this is new because I've never seen it in here, and I want people to know this exists. It's in the code. A rebuttal from affected parties, applicant rebuttal, LDR administrator rebuttal. Next, a conclusion that's available for affected parties, city conclusion, and then applicant conclusion. So I just want to state that this is all before deliberation and that the applicant presentation goes before affected parties and staff report. And for those who are affected parties, they'll read the definition for you, I'm sure, to see if you qualify. And then if you are an affected party, you have access to a rebuttal and a conclusion. And that was something I learned, and I wanted to share that. So.
Thank you.
Soorya Lindberg, Soorya Lindberg.
Mr. Walker, Mr. Thomas, is there anything we can do to address the crowd and
What I would suggest that we do is we're taking up C and D on the agenda. That will alleviate some of the crowding. So let's address that after we finish with those presentations. And in the interim, perhaps one of our staff members can talk to law enforcement and see if it's appropriate to, if law enforcement says the doors need to be closed, then the doors are closed. But if they have discretion with that, let's find out what that is and see if that can be accommodated.
Okay, very good. Order. There'll be no outbursts from the crowd. All right, board members, are you ready for a vote? All in favor, say aye.
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 Aye. Aye.
Motion passes. So we will hear item C.
Mr. Chair, this is a legislative item and we'll turn it over to staff.
Mr. Chair, may I say something real quick? I know the applicant personally, so I would like to recuse myself from this item if that's.
Do you believe that your vote would be biased or that would because of your personal relationship? A couple of questions. First, does it inure to your own private benefit? Is there any connection such that you would benefit financially if this was approved or denied?
No, sir.
And do you believe that your personal relationship is such that you would not be able to vote in an unbiased manner?
I don't believe that my relationship would affect the way that I vote. I just don't want perceived bias.
And this is your determination at the end of the day as to whether you desire to vote or not. So if you desire not to vote because of that relationship, I think that is your decision to make.
I would prefer to sit this one out.
Very good.
Okay. Good evening, Chair and board members.
Good
I am
evening.
Bernadette Fisher, Principal Planner with the Department of Planning and Community Development. Before you today is case PSSC 25-002, the Mallard Construction and Electric Small Scale Comprehensive Plan Amendment. An overview of this request is presented to you by NV5 as the applicant and agent and on behalf of Mallard Construction and Electric. And this is to amend the future land use map from agriculture to community commercial, and the site is measured at 1.35 acres. The subject property is generally located at Northwest US 441 and west of Northwest 164th Lane. The applicant submitted a companion application for a site-specific amendment to the zoning atlas. This is a picture to give you an idea of the vicinity of the lot that's north of US 441. Okay. Sorry. And this is to give you the information in regards to the existing future land use that's designated to the property today, which is agriculture, and it has the purpose to maintain agricultural operations within the city limits, as well as preserve the rural character. And this property at the current zoning, future land use, would allow for one dwelling unit on the property, and it allows for 50% floor area ratio as far as for any commercial development. And the typical uses is a single-family detached dwelling unit, supporting community service, agricultural production, and education, and horticulture. And this is a map to give you an idea as to what the existing land use is, agriculture. And what is being proposed is community commercial, which the purpose of that future land use is basically to provide neighborhood and community scale goods and services to the adjacent neighborhood as well as residents throughout the city. And this is a map to give you an idea as to what the proposed zoning is. I keep wanting to call it zoning, future land use. The community commercial. And the applicant was required to do a neighborhood meeting. And the purpose of the neighborhood meeting is to educate the owners and nearby land and interested parties. And this meeting took place on September 29th. And from the application material that was submitted, there were no one that attended this meeting. Okay, the need analysis for the proposal is basically required according to Chapter 163, 3177 of the Florida statute. And also the comprehensive plan must provide land to basically accommodate at a 10-year planning period. And this goes into what the applicant contends, which is basically to develop the property as a business to provide goods and services. We did an urban sprawl analysis to determine that what they are proposing is not going to create urban sprawl. And this was based on Chapter 163.3177 of the Florida statute. And there is 13 primary urban sprawl indicators that we have to review, as well as 8 urban farm criteria. And based on the evaluation, staff concluded that the amendment does not constitute urban sprawl. Following that is the comprehensive plan consistency. The application has been reviewed for consistency, and it meets the specific goals, objectives, and policies that supported the application, which is the future land use, infill development, transportation, and community facilities. And this is a map to show the segment in which this property is located along, which is segment 6. And this is to show that there's all of the environmental conditions were satisfied based on the analysis. Staff recommends that the Planning and Zoning Board find the small-scale comprehensive plan amendment for Mallard Construction and Electric, LLC to be consistent with the City of Alachua comprehensive plan and transmit the application to the City Commission with a recommendation to approve. And I conclude, and we'll stand for any questions.
Members, do you have any questions?
Thank you, Mr. Chair. I did have one question with regards to the staff report.
Mhm.
I noticed, and it's not a big one, given the size of this development, but I did notice that on January 1st, the city released its concurrency report, on the website. I'm assuming the public has had access to it. And that shows 3 million gallon per day permitted capacity on water. And that source is December 25 Public Works. Then this particular staff report shows current permitted capacity as 2.3 MGD. So, and the reference on this one is April Public Services. So I understand why the numbers would be different, but why was a different capacity used in this staff report? Was it a timing issue when you had to complete this report, or?
Yes.
Okay. All right. So I asked that because the other application is using 3 MGD and the other item.
Yes.
All right, thank you.
You're welcome.
Any other questions?
Okay.
Is the applicant here?
Good evening, Mr. Chair. Craig Brazier with NV5 representing the application this evening. I do have a presentation, but out of respect for your time and the agenda, I'm here to answer any questions. I just want to reiterate a couple of things about the application. We did notify and hold the neighborhood workshop, which no one did attend. The surrounding land uses and eventually zoning are consistent and compatible with this application. And the true intent of this application is to allow an existing local business to develop an office space for their current use. So with that, I'd be happy to answer any questions that you have.
Okay, thank you. Staff, do you have, or board, do you have any questions? All right, I'll entertain a motion. Okay.
Mr. Chair, I can go ahead and do that. I move that based upon competent, substantial evidence, the presentation before this board and staff's recommendation, this board finds the application for a small-scale comprehensive plan amendment for Mallard Construction and Electric to be consistent with the City of Alachua comprehensive plan and transmits the application to the City Commission with a recommendation to approve.
Second.
Very well. We have a motion and a second. Is there any public comment on this? Having seen none, all in favor, say aye. Aye.
Aye.
Motion passes.
The next item on the agenda is subparagraph D on the agenda, which is the second item. PR 250002. And again, Mallard site specific. This is the zoning component for the matter that we just were deliberating on prior to this. The order of proceedings is as read into the record already by one of the citizens. But first, we'll have the swearing in of all persons who intend to testify about this matter only. So if you're here for PR 250002, if you'll stand up, raise your right hand, and our city clerk will swear you in.
Do you swear affirm the testimony you're about to give is the truth and nothing but the truth?
And the witness has been sworn, and at this time, we're going to go through the board members and ask if you have any ex parte communications that need to be disclosed. Did you have any comments by anyone, the applicant or other members of the public, or have any knowledge about this application before this evening? If you'll put that on the record.
None.
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 And you don't intend to vote, so.
Aye. Correct.
All right, next is a description of the proposal, and our staff will provide the introduction.
Okay. Bernadette Fisher again. This is for PR 25-0002, and this is a quasi-judicial hearing for the rezoning. Okay, the request is again by NV5, and basically they are requesting a rezoning of the property that's located north of US 441. The existing zoning that is designated to this property is agriculture, which supports the primary use of land for agricultural and agricultural support uses. And this is a map of the existing zoning, which is agriculture. And the proposal is to change or amend the zoning to community commercial. And this zoning, it actually establishes the city LDRs with the general purpose of providing business uses that provide goods and services to the residents in the entire community. And this is the proposed zoning, which is the community commercial. And as mentioned earlier, this property was required to do a neighborhood meeting, which was conducted on September 29, 2025, with no one attending. And in order for the rezoning to be considered, we had to confirm if it's consistent with the comprehensive plan. And the specific goals, objectives, and policies that support this application were found in elements of the future land use element, infill development element, transportation element, and community facilities. And the evaluation is with specific goals, objectives, and policies, and they are included in the staff report. As far as the environmental condition analysis, we found that everything was satisfactory. And it had to comply with the land development regulations, which included the consistency with the comprehensive plan, consistent with ordinances, logic, development pattern, premature development, incompatible with, we had to, of course, compare it with making sure it wasn't incompatible with adjacent lands, that it's not going to create an adverse effect on local character, and that it's not deviating from the pattern of development that is inexistent, encouraging sprawl, spot zoning, public facilities, nor any adverse effects on the environment. According to 2.4.2E1A of the Land Development Regulations, the property was found to be consistent with the comprehensive plan. Following that is consistency with the ordinances. According to our analysis, it does comply, and that is not going to create any conflicts. On 2.42E1C, the logical development pattern, the property was found to actually follow the current development pattern that has been established along that segment of 441. 2.42E1D of the LDRs addresses premature development. In review of the proposal, it does not create any mature development of any undeveloped or rural areas. Okay, 2.42E1E, incompatible with adjacent lands. In review of the subject property, what is being proposed, what prompted the request to make these amendments, actually is compatible to what has been established along this segment already. Okay, 2.42E1F, as far as the adverse effect on local character, the proposed amendment is not anticipated to create any of the adverse effects on the local area. It would be more in character with what has been established. Okay, 2.42E1G, not deviate from pattern of development, which as mentioned before, what is being proposed as far as with the zoning is compatible to what has been established at this time. Okay, LDR 2.4.2E1H, encourage sprawl. The companion small-scale comprehensive plan amendment application has been reviewed against 13 indicators to make sure that this was not going to create any sprawl, and it definitely meets the requirements not doing so. Okay, as far as spot zoning, the application was not a result in spot zoning. 2.4.2E1J, public facilities. The subject property is situated within the community potable water service area and wastewater service area. Any future development on this property will be required to connect to those services. Then that's 2.4.2E1K, no adverse effects on the environment. An environmental condition analysis is included in the staff report, and staff did not find that this would create any adversity as far as the environmental conditions. Staff recommends that the Planning and Zoning Board find the small-scale rezoning for Mallard Construction and Electric LLC to be consistent with the city comprehensive plan and transmit the application to the City Commission with the recommendation of approval. And I will stand for any questions.
Thank you. Any questions? Does the applicant have any more presentation for this?
Again, Craig Brazier with NV5. Thank you for readjusting the agenda this evening. But I'll be brief. I just want to state that we have an we have a presentation, but I'm not going to share it with you. But I would ask that it be included as part of the record. I do want to reiterate that we properly advertised and held a neighborhood workshop. Nobody showed up. We are clearly consistent with the development pattern and the surrounding land use and zoning along this segment of US 441. We agree with staff report and staff findings. We ask that you do the same and recommend approval to the City Commission. And with that, I'll answer any questions that you have.
Members, any questions? All right. Do we have a motion?
I move that based upon the competent substantial evidence, the presentation before this board, and staff's recommendation that this board find the application for a site-specific amendment to the official zoning atlas for Mallard Construction and Electric LLC to be consistent with both the City of Alachua Comprehensive Plan and the city's land development regulations, and transmit the application to the City Commission with a recommendation to approve.
Second.
Well, it's been properly moved in second. Is there any comments from the public? Having seen none, this is a roll call vote. So, Member Highlander,
Yes.
Member Judd,
Aye.
and the chair votes aye. Thank you all.
Chair Smith, as the applicant for this particular matter, and perhaps others may be leaving, we may have some additional room for the folks that are in the lobby. I did speak with law enforcement. They did not have any objection to opening the doors, so the members of the public that are out in the lobby are available to listen to the presentation and that sort of thing. So we'll accommodate as much as we possibly can.
Thank you.
With that, our next item on the agenda, Mr. Chair, is PSE 220002, Terra April Special Exception Permit. As you heard earlier, there was a correct reading of the order of presentation as per our land development code. And at this time, anyone who intends to testify on this particular matter, if you'd stand up and raise your right hand, our clerk will then swear you in. Madam Clerk is making her way up and she'll do the swearing in.
Mr. Chair, Brenda Flieger, Planning Assistant. Next item on the agenda should have been meeting minutes for November.
Okay. Can we go ahead and swear all these folks in, and then we'll proceed with that?
Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
Thank you.
All of the witnesses have been sworn. My bad on missing the first item on the agenda. And at this time, we will go through the same procedure with our board members as to any ex parte communications. Please.
Mr. Chair, I guess I had a procedural question. Did I understand the city attorney to say that the doors would be open as in the folks in the lobby could hear? Or because I see them standing out there, don't know if any of those people wanted to be sworn in. So that's my procedural question.
It's a great question. So if we could open the doors now, and then if any of those members, when the doors open, we'll ask the question.
Thank you, sir.
We have one seat over here. There's one in the seat. It's not about seats, it's about count.
Okay, to everybody in the hallway who plans on speaking, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
Thank you.
And now we have our ex parte communication question.
None.
I have not.
No across the board.
I have had several conversations with the public, both before becoming a board member and after, but I intend to reserve my judgment for the presentation.
That is exactly the criteria. You've disclosed the communications, and nothing in those communications would bias you in such a manner that you would not be able to make a decision based upon the testimony in the record here this evening.
That is correct.
Okay, very good. We will begin the process now. Our staff will introduce the item. It should be noted that an applicant and affected parties in a quasi-judicial hearing get basic due process, which is something less than judicial process in a court of law. For members of the public, the rights are much less and dependent upon their interest in this proceeding. And then we will weigh any opinion testimony. Typically, opinion testimony is limited to those members of the witnesses that have designations, such as Brian, after a lot of letters after his name, ACIP, American Certified Institute of Planners, I believe is the designation. But that's who you take your opinion testimony from, Mr. Chair. There's one other item after the presentation by Brian. We would like to have Michael Alfieri, who is the city's geologic expert, testify as to many of the conditions he is suggesting be placed on this particular project. Our thought is that that will help perhaps speed up the process of the hearing. So with that, we'll turn it over to Brian.
Thank you, Mr. Attorney. Brian Thomas, AICP, and a few other alphabet that I'll leave out. Thank you. This is the special exception application hearing for the Terra Forest LLC quasi-judicial hearing for Planning and Zoning Board approval or review of the special exception for Terra April. A little bit nervous. There's a biggest crowd I've faced, honestly. The Terra April special exception, which would basically allow for the construction of 2 stormwater management facilities on property currently zoned agricultural. The request is being made by Clay Swager, also AICP, and a few other alphabet letters of EDA Consultants Incorporated, the applicant and agent for Terra Forest LLC, which is the property owner. The subject property overall is a little over 58 acres, but the project area in question that would actually be where the stormwater basins for the special exception be constructed on is approximately 6.25 acres. The special exception, if approved, would allow for the consideration of construction of 2 stormwater management basins as part of the Terra April Infrastructure Plan application. Terra April Infrastructure Plan will be presented at a subsequent hearing of the Alachua City Commission. It is not, just want to reiterate that it is not the subject of tonight's application. It'll come before the City Commission at a later date. The basins, if approved, will accept stormwater from the 10.5 acre site on the subject property, which is owned community commercial, and are proposed to accept runoff from the future development proposed by the same applicant. Here's an aerial overview of the total subject site of the Terra April Infrastructure Plan. Zooming in a little bit, you'll see the area depicted in pink is 10.5 acres. The area to the north, the green area that also has the red circles or red outlines, that is the approximately 6.25 acres where the stormwater basins would be constructed. This is more of a conceptual design than an actual design. The red that you see is where the perimeter trails will be constructed as part of the overall project. Then zooming back out a little bit, you can see where this fits in the overall Terra April plan. And with that, I would like to introduce the city's special expert on geological science. Michael Alfieri is a professional geologist licensed in 13 states, including Florida, and is a nationally certified registered hydrologist with almost 30 years of experience. Mr. Alfieri manages hydrological and water resource engineering teams in the evaluation, planning, design, testing, permitting, and construction of wells for potable supply, deep injection, and managed aquifer recharge. He is one of 4 groundwater professionals in the state of Florida to be registered by the National Groundwater Association as a certified groundwater professional, and one of 5 professionals in the state of Florida to be registered as a professional hydrologist by the American Institute of Hydrology. He's been on the Florida Board of Professional Geologists for over 13 years and has been chair and vice chair of the board multiple times. Mr. Alfieri's CV, case list, and presentation are offered for the record. City offers the following exhibits: Mr. Alfieri's CV, his case list, his PowerPoint presentation, staff's letter dating January 6, 2026 to the applicant, and the attached recommendation of geologic work from Mr. Alfieri dated December 23rd, 2025. And my resume is also available upon request. I'll offer this as into the record.
Thank you.
While Mr. Alfieri makes his way up to the microphone, I would like to also, Chair Smith, introduce to you Patrice Boyes. She's a land use attorney, special counsel to the city of Alachua. And I've known Patrice for all of her 35 years of practice. We've litigated together and worked on many projects together over those 35 years. So I'm very well familiar with her expertise in land use and planning matters. And she will handle the substantive issues regarding this application this evening. I intend solely to give advice with regard to procedural matters, and we'll leave it to Patrice Boy's capable hands to handle the substantive matter.
Okay, thank you very much. Yes, sir.
Yeah, good night, or good evening. Thank you for having me out here, Mr. Chair, Vice Chair, board members. Again, my name is Mike L. Fury. I work for Apex Companies. As you heard, I have going into my 29th year of being a practicing geologist. Yeah, maybe that's a little better. I'm entering my 29th year of practice right now. This is the presentation I put together on behalf of the city. We're going to start with my credentials. We're going to dive into regional and local karst features, and then recommendations. So I am the expert. Again, as mentioned, I'm 29 years in practice. I've been on the state board for 13 years. I was assigned to the board by Governor Rick Scott. Right now, the longest tenure on the board, which the board regulates the practice of geology across the state of Florida. We're the ones that authorize the applications for licensure. I'm licensed in 13 states, Florida being one of them. Sorry, I keep walking away. Sorry about that. And in addition, one of 5 that's registered as a professional hydrogeologist through the American Institute of Hydrology, and one of 4 certified groundwater professionals through the National Groundwater Association. I have numerous peer-reviewed journal articles, as well as a textbook, academic textbook that's used across the state of Florida for karst courses, which is right up there, with my co-authors, Dr. Tom Scott, Dr. Upchurch, Dr. DeBecke, and Dr. Fertisi. I'm the only one that is not a doctor. So nice lofty group there. I was also one of the lead authors and lead field guides for the National Cave and Karst Research Institute Sinkhole Conference in West Central Florida. We visited even some areas up here in Alachua County as part of the field trip. If you ever want to see what it is, the field guide is available through NICRI. So what I want to do here is start big, go small. And the thought I want you guys to have in terms of process is think medical. It's the easiest thing to go with. So aerial imagery and topography. We're starting big. So where is the area of interest relative to the county? Well, she's right there in the red. Counties in outlines in yellow. All right, this imagery is from, I believe it's just GIS imagery through Esri. We zoom on in, and this is the local area of interest. Now, the one thing that I want all you to pay attention to is on both slides, good, they're the same. The areas that have a darker tonal soil tone color relative to the ones that are lighter, because we'll be getting into that in a bit. On top of this right here, I have the parcels that are provided by the county shapefile. And here's our topographic map provided by the U.S. Geological Survey in the site itself. Using Alachua County LIDAR, which is topographic light imaging detecting aerial ranging. It is a laser that's essentially fired to the ground surface. You get your elevations from there. And as you can see, the scale goes from red to blue, blue being the lowest, white being the highest. Think like snow in the mountains, water in the sea. Now locally, to this area of interest, you could see that there is a low area within the area of interest. And you could see a couple of branches coming off of it with higher elevations to the east and west and a little bit towards the southwest. Again, going big, then going small. So what we have here is a presentation of closed depressions provided by the Florida Geological Survey and where they're located. Notice the concentration within western Alachua. Here's the closed depressions in the area of interest. As you can see, that bowl that we saw prior in the LiDAR is evident in here, as well as other depressional features. Medically, again, you're not going to go to a doctor who's just going to go whip out a scalpel and, do their thing to you. They're not. They want to start big and go small. So we start big, looking at these literature references, looking at the topography, seeing how land surface looks, because karst is a terrain land feature created by dissolution of the carbonate rock, which forms the Florida platform. Geophysics is like your x-ray. Okay, doctor gets you an x-ray. Now there's a bunch of types of geophysical methods you can use out there. Right now, for ease, readily available information, I went with microgravity. Now, microgravity is a standard geophysical test that measures gravity. It doesn't really change much over time unless there's serious collapse of features or if you have like metal next to your instrumentation, it can screw it up. But what we're showing here is the 1972 microgravity survey that was done across the state of Florida by the U.S. Geological Survey. The red areas, as you go from pink to red, are denser materials. I mean, the rock is a little bit more competent. As you go down the other end of the scale to the bottom, as you go from pink to blue, you start getting into this lower density material. That material there, that anomaly, that negative anomaly that's on there, is indicative of potential fractures, areas of water collecting, caves, things that we'd be looking for karst. So now going to geomorphology and structural karst features in the area. Again, this is from Christopher Williams et al. This is a geomorph atlas that was produced by the Florida Geological Survey by Christopher Williams, Dr. Upchurch, and Dr. Scott. And as you can see, the area of interest falls within the Ocala karst plain. Note the word karst. All right. Going smaller, within the districts, there are provinces. Think U.S., think states. Same type of thing. So within there, you got the Alachua Hills karst province there. You have Wilson's karst plain, all in western Alachua. What I'm showing here are two things. These are literature referenced faults within the area. Now, these are deep-seated faults, Jurassic-type material, so you're talking way, way beneath the surface right now. But the pattern of these faults mirror the stress-strain ellipsoid that puts pressure on the Florida peninsula, and it creates fractures in this northwest, southeast, northeast, southwest pattern, as seen in the rosette up there. And as you can see, the fractures follow those. And again, the closest fracture there is Jurassic age material, way, way, way below the area of interest. Moving on to other karst features. These are cave entrances. This shapefile is provided by the Florida Geological Survey. And what I'm showing here are three types of caves. You have mostly air-filled, mostly water-filled, and biosignificant caves. Again, note the concentration in western Alachua. Going to the area of interest level here, we got 4 entrances, 3 of which are water-filled, 1 is air-filled. 2 of those are biosignificant caves, meaning that there are the environment has biota that it's karst related, sometimes not seen in other areas and other karst systems. So again, to note the soil tones. Darker soils tend to be more saturated than lighter toned soils. Note the dry cave in the drier, lighter colored soils, while the other entrances that are water filled are all within those darker sediments. Let's move on to other features that everybody loves here. This is one of the reasons that folks love to come to this county and love to come to this area, the springs and swalettes. All right. This is at the regional scale. Again, this is provided by the Florida Geological Survey. We have swalettes on there in white. The wet sinks are in light blue, and the dark blue are the springs. To note, the northwest edge there, you got Olino and High Plain, the state parks. Very well-known springs in that area. The other thing to note, and does this have a laser printer or a laser pointer? But anyhow, there is a northwest southeast trend of swalettes as well as sinks, which also follows the rosette, which is good to see. All right, at the site area of interest, obviously we got one's Mill Creek sink being saturated. Next feature, I put this in here. It's from the Florida Geological Survey again. These are subsidence instance reports. Now, what is a subsidence incident report? That is any instance where the public reports to the Florida Geological Survey, they see something of interest, such as a depression, a sinkhole. It gets put into the database, and it is confirmed to be a sinkhole when the PG from the state goes and visits, determines it's actually a sinkhole, and that goes on the record. Thing to notice when we go locally, there really isn't much there. And why is that? There's no development. Farmers typically do not report a depression in their land. It's not going to really impact their cattle or impact their crops. So, when you don't have a lot of development, you tend to not see a lot of these reports. So, what I ended up doing here is I took photolinear interpretation and linear interpretation. Now, what is this? This is another screening method, a lot like geophysics. I look at aerial photography, I look for soil tone changes, and I'm looking how things may match up linearly. And the way you do this is you multiple years of aerial photography, and then you lay it all these days in a GIS, determine, do these things fall in the right patterns? Do you start seeing a pattern? Do you start seeing concentrations? So what we have here is 2008 aerial photography interpretation from FDOT, 2017 imagery from FDOT, and 2022 from FDOT. Okay, that is your blue, your green, and your yellow. Added to this, I put in linear features that were observed within the closed depressions. And that there is in the orange and oh, sweet. There we go. Thank you. All right. So there we go. So blue, 2008, green, 2017, yellow is 2022. Orange are linear features observed within the depressional shapefile. Red is linear features observed within the LIDAR, and the white is that Jurassic aged fracture. And if you note, all these features follow the stress strain ellipsoid, which is expected. And what you do when you have this type of analysis, because it is a screening analysis, the only way you can take the next step forward to determine, is this real? Is this not real? Is through testing. So, as you've probably read in the technical memorandum, I just want you to be aware that the dates obviously have shifted on there because of the meeting and things of that nature. But the recommendations were provided to the city staff in support of the evaluation of the applications. The recommended additional work will address geologic uncertainties and produce necessary information in interest of the public health and safety, the environment integrity. Apex, being me, recommends the comprehensive geophysical and geologic testing within all three property boundaries, and this investigation is essential to complete the geologic review that I started. to ensure regulatory compliance, protect groundwater resources, and mitigate potential hazards associated with the underlying karst. So the recommended work tasks as listed in the technical memorandum. First would be site visit, boots on the ground. You know, you can't make determinations from photographs, sadly, and I don't have X-ray vision, so boots on the ground. Again, when I was thinking of the medical analogy, we're starting out with geophysical. GPR is bread and blue technology. They do mapping here. The intent here would be do a grid of GPR to map out the depressional features or any anomalies that could be determined by GPR. Now, GPR radar signal was lost in clay. So areas that have clay, I can figure out where we have confinement, where we don't have confinement, because clay will prevent water from moving from up through the material to the aquifer below. Coupled with that would be electrical resistivity imagery. Now, ERI, as it's called, gets you a little bit deeper. It could punch you through the clay. It can see through the clay, get down into the rock to look for voids and other karst features. So when you have the GPR, I find anomalies, you see depressions. Those are the areas I want to do a little bit further investigation, like a doctor. So GPR is your X-ray, ER, there's your MRI. All right. Now, what do you go after the MRI? You got to go to surgery. So that's geologic testing. And what I recommend is testing depressional features as identified, any geophysical anomalies identified through GPR or ER. Okay. Or any areas where you have intersecting photolinears. It's the only way you can confirm it is through testing. Until that's just screening. Again, I would recommend in terms of these technologies that collect the relative density of the soils, get the stratigraphy of the soils. We're talking about standard penetration borings, SPTs, or cone petrometer tests, CPTs. Either or are good methodologies. One doesn't use water, one that uses drilling mud. So my personal preference is avoid adding fluids to the system. So CPT is usually my preference of choice. And if that testing is completed, so we have our screening technology and then our verification through ground truthing and testing, the technical memorandum would be provided to the city by, in this case, the applicant. I would review and make sure that it hits all the targets in terms of what I suggested and recommended, and I'd be looking at to see what was found in terms of karst and provide that information to the city. And with that, I thank you. And if you have any questions, I can answer them right now.
Members, do you have any questions?
Yeah.
Thank you, Mr. Chair. So the recommendations that you concluded with, are those the same as in your December 23rd task proposal to the city of Alachua that I believe was sent via Ms. Boyce?
Yes.
So they are verbatim the same?
I believe so. I believe I just copied and pasted them, to be honest with you. There we go.
Okay. I'll get to my other items about that as we go through the process, but I just wanted to verify that. Thank you very much.
Yeah, no problem.
And Mr. Chair, just to advise the board, Mr. Alfieri will be here for the entirety of the hearing, and we'll make him available along with Mr. Thomas for cross-exam when the city presents the rest of its case. So we know we took him out of order, but just to set the table for public discourse.
Oh, and my apologies, Mr. Chair. So in the December 23rd communication, it talked about having certain items done by January 1 and then certain items done to early January. Has any specific task order work begun?
The photolinear analysis that's referenced has been completed. You saw that this evening. His literature review was completed, and you saw the results of that. The other item that could have been done the first week of January was his site visit, but that, depends on coordination, and so that could easily be done in this next phase.
And so then, in essence, your final conclusions, if you will, based on competent research and your qualifications that you presented to us this evening, that information is not complete as of this evening.
100% correct.
Right. And Mr. Chair, you'll notice in the packet from city staff, and Mr. Thomas will get into this in great detail during his presentation. Staff is recommending that a condition, should the board be inclined to approve the special exception, staff is recommending that a condition be appended which would delay the final effective date of the special exception until such time as the work Mr. Alfieri has recommended is A, completed, analyzed, B, any re-engineering that might be necessitated is also presented to the city. And so we will take you through that later in the proceeding.
Okay, and then one follow-up on that. When you're saying to the city, that would mean city administration, right? In other words, whatever QJ action we take tonight would set the table for what follows, correct?
As far as the
SE,
the work?
No, the special exception decision that we're going to be
Right.
asked to take this evening.
Right. Staff will present a list of conditions, I think it's 10 or 11, which would be appended. This one is what we would refer to as a condition subsequent. So we're not taking effect until the work is done to the satisfaction of our expert.
Right. I think I got that down. And then this may be a city question real quick. Excuse me.
No, go
So
ahead.
the task orders range from a base, and I think it's for items 4 through 6 of 18K to I think it was 28K. So who's paying for that, the city or the applicant?
So there's two cost aspects to it. Mr. Alfieri has given you an estimate of his fees to perform his part of the work. I want to make that very clear for the board. The estimate to do the actual geophysics and the drilling has yet to be determined. And that, of course, would be borne by the applicant. Staff can answer this question more fully, but you do have the ability under your code to require reimbursement of the city for Mr. Alfieri's fees as well, because he is an outside expert that the city staff determined was necessary to evaluate this application.
Thank you.
Thank you, Michael.
Appreciate it. Thank you, guys.
If you'll be available for cross-exam by the affected parties later, I'd appreciate it.
Absolutely.
Okay.
Do we have more
So-
presentation from the city?
Not at this time. We'll do that at the end. We'll revert now back to the familiar order of presentation in your code. So the applicant will present their case next,
Okay.
followed by the affected parties. And by agreement of the affected parties, just so the public is aware, the National Speleological Society will present first. Of course, the chair will have to admit them as an affected party, followed by Alachua County. In their presentation, again, they'll present their basis to be admitted as an affected party, and we have a third individual who's requested affected party status, and that individual would come third. So that will be the next section of our presentations for the public's benefit.
You said the applicant.
The applicant is next, and Ms. Vanette Godelia is here with her team.
Hi, good evening.
Good evening. Ms. Brenda, I don't know if you can forward to slide 27 here, or maybe I can just do it myself. Let's see. Should have moved it to the beginning, but here we sit. How many times have I clicked? Not 27 yet. Oh, yeah. Okay. It's on the comp plan policy. Good evening, board members and audience and all. My name is Vanette Godelia. I am an attorney with the law firm Stearns Weaver Miller, based in Tampa, and I am here on behalf of the applicant for the special exception application that's pending before you. The hearing's been a long time coming. Brian did a great job focusing on what this request is for. I think it's clear from the communications that we have seen publicly available that there is some confusion about what's being asked for. So Brian did a good job I'm going to focus a little bit more on that. Clay Swager is here, is going to be our star witness. This is a planning application. It is a special exception approval, which is akin to a special type of, level rezoning quasi-judicial approval. It is not a technical application to the extent, for instance, that you would do an infrastructure plan, which is an application that goes before the city commission, not before the PZB. So this is a land use approval. And so we have Clay presenting because he's an AICP planner with over 24 years of experience. And I think you all know him. He works here. So he should be a known entity, and he's carrying this presentation today. I also have with me Miss Susan Stevens, Esquire. She is my law partner at Stearns Weaver Miller and has over 30 years of experience in the environmental permitting world. She focuses on environmental permits. I focus on land use, but she is very competent and qualified to discuss matters related to regulations of the water management districts, the DEP, all of it. And so she's going to do just a couple of slides for us late in the presentation to explain to you what all has been done to get us to this point. And then we have others in the audience as far as being able to respond to your questions. We're not going to have them up here to present, but we do have our engineer that designed the stormwater infrastructure that we're here about today. And we have another engineer who will be assisting us in coordination with Ms. Alfieri on how we go about complying with the condition that the city staff is proposing. And I'll discuss it a little bit later at the end of all this presentation, but we also have those people here. So again, the special exception is for the Terra April commercial basins. And the reason I have this policy up is because I wanted to just point out, there's a trigger, right? That the city long ago identified, 2021, maybe not that long ago after all, but the city amended its comprehensive plan and they said, okay, we have a problem. The problem is the water. We're going to treat the water. From I-75, it free flows. You see the direction of the arrow, but they put in private developer will fund this, and the time frame of when this gets picked up is at the time that this private developer landowner decides to proceed with some commercial component of the development on the larger parcel. That's where we are. So because that became the plan, could not move forward, cannot move forward per your policy unless the construction takes place for the larger facility to serve I-75. And then Mr. Thomas focused in on the two smaller basins or ponds that were further south on the parcel, which would serve the commercial development. So it's part and parcel. You can't move forward with one without the other. And so that became the trigger from a timing perspective. And that's why we submitted an application back in 2022, if you can believe it. And yeah, we crossed the thresholds. It's 2026. So that's why we're here. So I did want to respond also, or just before Clay comes up, to give some context again about this policy. As interesting positions that we seem to see being taken from folks that advocate that the water doesn't need to be treated, that it should be allowed to continue to flow freely into Mill Creek Sink. And to be clear, the data and analysis from 2010, 2020, 2022 was clear that the reason the water was being treated and why the city required it and put it in the comprehensive plan was to protect Mill Creek Sink. That was the reason. It's all in the record. So it's interesting to kind of hear this position of let the water keep flowing from the allies. But regardless, the city did what it did, had a financial plan. The trigger is commercial development. That is what is being proposed now, is to go ahead and move forward with that solution. What's not being requested, I want to be clear again, there's no additional density being proposed for residential development of any kind. There's no intensity, office, commercial, industrial. No additional intensity being proposed by the special exception. There's no approvals for Terra Phoenicia. And I know we talked about when Mr. Alfieri did his presentation that his condition does speak to some infrastructure plans that are pending for other properties. And the applicant will, discuss compliance with the policy or with that condition. But for this board, there is no approval for Terra Phoenicia under consideration, no approval for Terra Forest West, no other Terra project is April, and it is stormwater infrastructure for April. Zoning land use approval, that's kind of where we are. And if successful tonight, you would give us permission to move forward with the detailed infrastructure plans, including doing the work that Mr. Alfieri will be recommending through staff and through you, again, if you agree, to get that done. So that's what we're asking for. And Clay, come on up so we can start the presentation. It's going to be a long night, so get you back to the start. I'm sorry. Lots of pretty pictures. There you are. Thank you.
Good evening, Mr. Chair and board members. I'm Clay Swager. I'm a certified land planner with EDA Consultants. The agent here tonight that has put this planning application together for your review. As Ms. Vanette indicated, there are some other folks here, part of this project team, to help answer questions that you have. This is an interesting project, a lot of interest, obviously. A lot of times this room doesn't have anyone in it. But I'm going to continue just to do what I normally do and just walk through applications and the planning materials that are relevant to your considerations, and then we'll be here to answer questions tonight. I'll probably just have to take a little bit longer than normal, but I'll probably about 15, 20 minutes, and I'll sit down. As staff indicated, this is one tax parcel in the city of Alachua, approximately 58 acres. It is near the intersection of I-75 and 441 off of April Boulevard. Just a quick outline of the topics I'd like to go through with you tonight. The timeline of past approvals, where we are tonight, and what subsequent approvals might look like. What does the master plan entail? What are some of the benefits of the project? How we are consistent with the special exception requirements in the city code, comprehensive plan consistency, and relevant data and analysis. So as Vanetta indicated, we are here just to talk about a special exception for this parcel tonight. I know there are other properties of interest and other projects, but I'm not the agent for those. That's not what's on the table for you tonight. So I'd like you just to bear with us here as we talk about, the application in front of you. So just going back in time a little bit, about 15 to 17 years ago, the property owners at the time really started to acknowledge the unique characteristics of this land and try to do some master planning from the land use and zoning level. At that time, the property owner did take their 356 acres and work with the city of Alachua on a series of land use and zoning map changes, which resulted in about 62% of the overall, what was known as the McGahee properties at the time, about 62% of that being placed into either conservation, which is really that swath of land with Mill Creek meandering through it in the middle, and some recreation land use areas sort of on the buffer or periphery on each side of the conservation areas you can see on that map. Subsequent to that, the property owners have dedicated some land for city projects and public purposes, like a dedication for a lift station location, public utilities, easement donations. Those have happened over subsequent years. And so our involvement began in 2021, working with the city of Alachua and the property owner. That a series of applications were brought forward, a land use map change, comprehensive plan amendment, a rezoning that matched the land use change, and also a text-specific policy, which Vanette indicated, that was related to this property, and it had a requirement to provide stormwater treatment for FDOT runoff that runs from I-75 eastward to Mill Creek. And so those were all brought by my client and the current property owner in consultation and coordination with the city. Also, I would note almost 7 acres of land were placed into conservation land use and zoning. Those were a result of a on-site environmental assessment done by Verde Environmental. So all the wetlands, all the wetland buffers were put into conservation land use and zoning at that time. And as you can see, I think I have a laser pointer. Yeah. About 10.5 acres of land were approved by the city of Alachua for commercial use. And so, as Bennett indicated, there is a site-specific comprehensive plan amendment, which I did work on at the time, companion with these land use and zoning changes that placed a requirement that's now in the city's comprehensive plan to treat untreated stormwater runoff from I-75 that discharges eastward to Mill Creek. The timing of that requirement to build that stormwater treatment is before or at the time of any commercial development on that 10 acres of commercial land use area that's on the map today. At least a ½ inch of runoff for a certain part of the I-75 is required for treatment. That's a minimum. And then also there has to be active and passive recreation, passive recreation form of pathways and nature trails. Well, I'll show you a master plan in just a minute that shows you the location of those trails. Stormwater, walking and biking trails must be privately owned and maintained. So those are all codified in the city's comprehensive plan today and is folded into this special exception application that's before you tonight. Just a couple comments. As you know, I did go back about 15 to 17 years in time, which is when things were starting to materialize as far as planning of this property. There have been at least 18 public hearings over that time. Planning and Zoning Board, City Commission for land use and zoning approvals has been quite a bit of engagement. Obviously, a number of neighborhood workshops over that time. These public hearings are in addition to the neighborhood workshops, and that there were testimony was given at all those hearings related to these approvals. And my recollection, there were really no objections. I think everything was viewed very favorably as far as the direction, particularly the treatment of FDOT runoff and the approval of about 18 or 19% of the site to be used for commercial uses. One thing I didn't mention, and I apologize, planners were a bit repetitive because we have to go through criteria, but and I'll mention this again, but part of that comprehensive plan amendment as well is that there would be a limitation on commercial activity, and that it would be no more than what is allowed in community commercial. And we're going to take that a step further in this application and further limit proposed commercial uses. So today you have a special exception before you. This is not a construction permit. This doesn't allow development of the site. This is a sort of a use zoning type approval of what's being brought before you to provide 2 stormwater basins, stormwater management facilities, dry, shallow retention basins that are considered in the city code as minor utilities in agriculture zoning. And they're being proposed right next to the commercial zoning area. So the City of Alachua LDR 4.3.2 provides a mechanism for stormwater on properties with less intense zoning, and that's really the crux of the origin of this application. The reason that we're here for a special exception is that proposed stormwater retention in the agriculture zoning. It provides an ability to construct stormwater treatment immediately adjacent to the commercial zoning properties. There are no other uses of that stormwater other than to serve future commercial development. And those basins have been sized in a way, and my colleague on the civil engineering side of our firm created those conceptual size basins just to serve future commercial development with an assumption of a certain amount of impervious area that would certainly accommodate any type of future commercial development that would come forward. And this application will facilitate construction of the stormwater treatment for I-75 runoff that I have mentioned a couple times. So this is just a simple location map showing this 58-acre parcel, very long linear piece of land running along April Boulevard and just west of I-75 or east of I-75. This is just another image showing the city's future land use map. The dark green is conservation. The lighter green is recreation land use. The sort of light red is commercial, about 10 and a half acres. So about 81% of this property outlined in red is either recreation or conservation. Again, as I mentioned, all the wetlands and buffers have been placed into a conservation land use status. And this is the corresponding zoning map. The dark green, again, is conservation zoning, which overlays with the land use. The light green is agriculture with the A symbol, and CC is the 10.5 acres of community commercial zoning that is on the property today. I've got this image on a few different slides, but this is the special exception master plan. And it depicts various elements of the application, how they provide a superior benefit to the public through the provision of these stormwater treatment basins, trail networks, and added use protections. So the two basins that are proposed to serve the commercial development in the future are identified here. The basin for the FDOT stormwater treatment, which does run from I-75 to Mill Creek, is shown here. As I mentioned, there are a limitation of commercial uses that are allowed in the zoning area above and beyond what would be, I should say, actually below what would be allowed in the community commercial. I'll go through that for you in just a moment. So the trail network is shown in red, and it's over a mile of trail systems, and they rotate around these dry retention basins. They link this area, which is really a recreational natural area. It provides a stub out to this conservation area for future potential nature trail access, and also a connection and a requirement to have a trail through the commercial development area. And then ultimately it also connects to the Mill Creek stormwater enhancement area, which was a City of Alachua project that was brought online a few years ago. And so all of these would be linked. 3 or 4 uses would be linked by this trail network. That is one of the requirements of the comprehensive plan, at least for it was required for this basin, but our special exception takes it and connects and links all of the uses on the property. So the specific request, as I mentioned, is to permit a minor utility, which in the city code includes stormwater basins and agriculture zoning, to support future development in the commercial zoned area. It implements this master plan that I've shown you tonight and makes feasible the construction of the I-75 stormwater treatment area. I will go through a summary of benefits. I'll try not to be too repetitive, but in general, we do limit some of the commercial uses that would otherwise be allowed in community commercial. My next slide, I'll give you more of a list of those. Public, pedestrian, and bike trail network interconnectivity will be required as part of the special exception to link these open spaces, the commercial development, and the city's stormwater treatment park. We also have a requirement we're proposing to include an interpretive kiosk to explain the merits of the Mill Creek Stormwater Enhancement Park that has been provided by the city. And of course, the treatment of the I-75 runoff. So a few more comments on project benefits. Limitation of some commercial uses with potential that could harm water quality. There are some commercial uses that may be less compatible with areas when you're concerned about water quality. We are proposing to eliminate all of the uses that are listed in bullet points below that otherwise would be allowed by right in this community commercial zoning area, including gas stations, industrial service, which has a long laundry list in the city code, but it includes fuel oil distribution and different types of industrial activities, tire sales, mounting, parking lots. All these would be taken off of the list of possible commercial uses to just to pare that list down to something that is a little more compatible with the area, if you will. Again, public trail network and interconnectivity. This would all be required to be constructed with private dollars and open to the public for public access to link all of these uses. Would have to be done at the time of any future commercial development. A site plan would come into the city, whether it's for a shop or something like that, and they would have to show that these trails have been fully executed. As I mentioned, the interpretive kiosk by the City Mill Creek Stormwater Enhancement Area would also be provided as part of this. So I'd like to go through some of the criteria, the review criteria for you regarding the special exception. There are essentially 8 main special exception standards, which are shown on the screen, and I'll go through all 8 very briefly. Your staff report, which you'll hear tonight, they are recommending approval of this project. They do, their professional opinion, along with mine, is that we do comply with the specific approval criteria for this relatively narrowly focused application tonight. But let me walk through those for you. So the first one is that the use complies with use-specific regulations. So in this case, the specific use is a minor utility, which the City of Alachua Code includes stormwater detention and retention facilities. Minor utilities typically are allowed in every zoning district in the city except for conservation. But in this case, because it's proposed in a different zoning district than the commercial, the special exception applies. But we do need to show that we comply with those criteria in 4.3.2. And so the first of those points is that the zoning location of the stormwater detention and retention allows minor utilities. As I mentioned, table 4.11 in the city code states that minor utilities are permitted in the agriculture zoning district. So we comply with that standard. Let me get my, okay. Number 2 is that we meet the compatibility requirements set forth in this section. And I'll speak to compatibility in a few places here as we move forward. And we also have to demonstrate that we provide an enhanced natural or recreational functional use. And we do have that trail network to meet that requirement. We also have an approval from the city manager that early on this process identified that they concurred that this trail network would work and would qualify, if you will, as a recreational functional use. And so that's a big part of our application. The stormwater area is designed to utilize the existing topographic conditions, providing that transition from an interstate to environmentally sensitive areas on the other side to the east, particularly with that water treatment. The basin's amenities and improvements provide a functional recreational use with the interconnected trail over a mile long, the interpretive kiosk to the Mill Creek Water Quality Improvement Project area. And this will help make it financially feasible for the developer with private funds to build that stormwater quality treatment area. So a few more comments. Number 2 is compatibility, and I'll talk about that more on the next slide. Subsection C regarding exemptions is not applicable in this case because we're not considering 2 residential districts or business districts. So we can pass over that. So again, about compatibility, special exception is appropriate and compatible with the character of the surrounding lands. That's the standard that you have to consider. And so a minor utility, in this case, which is a stormwater facility, is compatible with the surrounding uses. As I mentioned, most zoning districts allow it by right. There's no vertical structures, there's no noise, sound, odor. It's essentially a dry landscaped retention basin. So by nature, it's not a incompatible use with surrounding uses. Minor utilities are compatible with the overall surrounding area and that development pattern that's in place. We are implementing the comprehensive plan policy that requires the stormwater treatment from I-75. Implementation of the special exception conditions will further increase the compatibility of the proposed use with surrounding properties. I would refer you back to our our proposal to eliminate some of the more intensive commercial uses from being allowed on the property. So number 3, the design minimizes adverse impact. By nature, a stormwater facility, a dry retention basin, is not a negative visual, auditory, or other negative impact on adjacent properties. And that the design minimizes the environmental impact. And so there's no deterioration of light, water, or air resources. We're located next to a conservation area. That's stormwater and treatment and discharge of that water into a conservation area is compatible. Will not have a negative impact on nearby environmental resources. We avoid all wetlands, wetland buffers, and flood zones. These basins are not located in any of those areas. They're to the east. We've also had a thorough stormwater design and review and permit approval by the Swanee River Water Management District Environmental Resource Permit, and they issued stating, among other things, that no impacts to wetlands or surface waters are proposed or anticipated, and that the basin in a companion improvement plan or infrastructure plan is consistent with the city land development regulations, section 6.9.3. Number 5, roads and other public facilities. The fact that this doesn't generate traffic or facilities impacts, we don't believe that there would be a negative impact on roads. Number 6, it would not injure neighboring land or property values. We do not believe that this will injure neighboring land or property values. That does not generate any increased demand on roads, utilities, other public infrastructure. There's no noise, odor, or other potential nuisances that would affect land values. And the proposed stormwater quality treatment adjacent to DOT will be an environmental benefit. Drawings. The special exception master plan is the drawing that is part of this application that I walked you through very briefly. The city staff report actually indicated that a minor utility is exempt from the site plan requirement, but the special exception master plan has been submitted and reviewed as part of the special exception permit application. The master plan demonstrates that the proposed use complies with the applicable requirements of the LDRs. And finally, number 8, complying with all other relevant laws and ordinances. So we believe that we comply with all other relevant laws and ordinances in the city of Alachua and otherwise. As I mentioned, we do have an environmental resource permit that was a result of a review and approval by the Swanee River Water Management District. The Florida Department of Environmental Protection and FDOT also reviewed the previous comp plan amendments that went on the property, so they've had a chance to review elements of this this property as well. A few slides for you regarding comprehensive plan consistency. So I just want to remind the board that we do have approximately 10.5 acres of commercial land use on the property today, which does allow a wide variety of retail and service type uses. That's there. That's adopted and part of the property today. And we are proposing to remove some of those more intensive uses and have them excluded as a condition of approval of the special exception. I'm not going to read all this. This is the full entirety of that condition that applies to this property. Policy 1.3I. That is the requirement that on-site stormwater quality treatment for the DOT runoff will be provided at or before the time of any commercial development at least ½ inch of runoff of the drainage area adjacent to the property on I-75. It also requires that we have the active passive recreation and the nature trails. It also indicates that these will be privately owned and maintained. This is not to become a burden on the city once it's put into place. Almost done. So I think I jumped it. This is the summary of that policy. The treatment of the FDOT runoff, the usable trail interconnected network, and the reduction of some of the more intensive commercial uses will be a result of this amendment or this application, and it will help implement that comprehensive plan policy. So there are many policies in the comp plan regarding recreation. We believe this nature trail is certainly a recreational use that's consistent with the future land use element. There are provisions about encouraging development standards with innovative and flexible development that utilize and address natural features available facilities and services. So we think this is an innovative approach to improve upon what could be done in the commercial area, to tie in the FDOT treatment area with over a mile of trails, and to also highlight the city's Mill Creek stormwater improvement area, to really just have this thing more master plan than just a piecemeal approach over time. Conservation and future land use element. Again, all of the land on this parcel that is either a wetland or a wetland buffer has been put into conservation land use and zoning will be permanently protected and not impacted. All FEMA flood zone areas on the property are avoided as far as any proposed basins. And that I will just reiterate the Water Management District's review related to no impacts to wetlands or surface waters are proposed or anticipated. Water resources. The city shall protect and conserve the quality and quantity of water resources. We do believe that this FDOT treatment will serve and support that objective. And also the reduction of some of the more intensive commercial uses will lend to that as well. Recreation element. There are several policies in the comp plan regarding recreation, promoting public and private partnerships. Again, this would be a privately constructed trail system that would connect several different types of uses as part of the special exception. Community facilities and natural groundwater aquifer recharge element, stormwater. There are provisions and requirements in the city comp plan and code for stormwater treatment. We believe that we will meet those, all of those requirements. So I'm almost done. I've got a brief summary of permitting, and I've sort of mentioned it to you over this presentation, but there have been a lot of different public hearings and approvals on this property, including the site-specific comprehensive plan policy regarding the DOT treatment, the land use and zoning changes, putting the wetland areas into conservation and approving the 10.5 acre commercial land use and zoning, and also the approval of the environmental resource permit from the Suwannee River Water Management District, which is still valid and in place. So tonight you have the special exception that was submitted quite a while back. That's for your review and consideration tonight. Subsequent applications would include an infrastructure plan, and those are essentially construction plans. Those are technical engineering drawings that would show the exact design of everything that would be proposed as far as these basins go. The special exception is a planning type application regarding more related to uses or not allowing uses. So there will be another opportunity for the city, if this were to be approved, to review the technical engineering drawings. I understand there are some conditions that staff is proposing that may help bridge the gap on some of those issues. And at this time, I'll conclude, but I would ask Ms. Stevens to come forward and just give you a few final remarks. Thank you.
And hello, again, I'm Susan Stevens, attorney with the law firm of Stearns Weaver Miller, representing the applicant. And I just wanted to touch on a few things. We've had a lot of discussion about the history and the record, and there's been a lot of discussion that you're coming forward and you don't have enough information to assess the special exception standard of minimize environmental impacts. Well, there is a lot of information in the record that you've been provided that were from these other records that we packaged up and submitted to you, and I wanted to kind of point out where they were and let you know what those are. The existing conditions of the property, the assessments that have been done over time, the findings that have been made by our own consultants and consultants retained by the city to review the project. And so first, not in a particular order, but to group the environmental assessments together of the site conditions, we have one that was done back in 2008 during the original proceedings that Mr. Swager talked about. And also, and that's located in the massive PDF package that was in the record called the Revised Application Package 11/2008. And you can find that it's in there multiple times. The way this package is, the agenda package works. That's at page 124 of that massive PDF, to just kind of orient you on that a little bit. There's also the Verde environmental report that you heard about that resulted in the conservation of the more environmentally sensitive pieces of the property. And that was performed in July 2020. And that is found in the next massive PDF package you were provided. And that was entitled, that package is the, where did it go? The agenda package for the March 8th, 2021 City Commission meeting on the rezoning application. And that's found a couple times in pages 186 and 217. And I point those out because they are an evaluation of the environmental conditions. They demonstrate that the environmentally sensitive areas of the property were avoided and considered. Turning to that, we have some of the discussions of what was retained by the city, reviewed the Verde report. He was specifically tasked to look at the impacts because of the fact that it was upgrading it to Mill Creek Sink. He did that. They had recommendations. They said, look at the Water Management District sensitive karst criteria, and that environmental resource permitting process that you talked about will be addressing those criteria. And in fact, they did. And that wood report for the entire April property is also in that same package of material, and that's at page 83, and then a responsive email when they said their comments were addressed and they had no further questions. And after some back and forth, we're at page 115 of those materials. And you have another, I won't belabor all the locations of those, but we have some other reports in there back and forth with the EDA. And I wanted to point out another item in the report was CHW was hired specifically by the city to review the Terra April Comprehensive Plan Amendment package. And it's in that same package of materials. And they were asked about the public benefit associated with this project, and they found a public benefit from treating the I-75 runoff. And so that was specifically in the records, a consultant hired by the city to review this project. And so those are just some of the records. I won't go through any more of them in any detail than that. Another package of information that we provided was all of the environmental reports and the ERP issued by the Water Management District, its technical staff report, and the stormwater drainage, stormwater modeling report and drainage report submitted to the Water Management District. The GSE geotechnical investigation, which we did rely on site-specific site visits, multiple soil augurs, and laboratory testing of that data, and review of the literature review that we were talked about as being needed. That was all part of the review package. It was reviewed by the Water Management District. It was reviewed by the stormwater engineer and supported the stormwater modeling that said, hey, this is how these systems need to be designed. This is how we will design these. We also have the design plans that were submitted to the Water Management District. They're not before you today, but they're detailed plans that show exactly how these things are to be designed to conform with the Water Management District's criteria. And then you end up with the issuance of the ERP based, and there's some other matters, the Cultural Resource Assessment Survey. Again, that Verde report was resubmitted to the Water Management District, so they knew there were not going to be impacts to wetlands or other surface waters. And all of that resulted in the issuance of the permit, which constitutes reasonable assurances the water quality standards were not going to be violated, that the adverse impacts to the water resources of the district, including Mill Creek Sink, including the Swallow, would not be adversely impacted. And there's a laundry list of other reasonable assurances, determinations that ERP represents. That is their determination that it met the standards, that it would not cause these adverse impacts. So we posit all of that is in the information is in the record. We posit that demonstrates the requirements to meet for the special exception standard, that it's not going to have environmental impacts. So the record is not devoid, as has been suggested, of that demonstration. It is there. And just pointing out, and I'm going to be very quick on that, we have some final findings from the city's own consultants. You have, they specifically determined in the Wood report, again, that the sensitive karst criteria evaluated by the Water Management District would be protective. And that was his review of the Verde report for Terra April. The CHW report, as I mentioned already, and so I won't touch on it again, that's the quote from their report, that it found that there would be a public benefit associated with the Terra April project. And then your December 8th, 2020 staff report of approval also recognizes the importance of the Terra April project for to protect Mill Creek Sink from untreated stormwater runoff. And so that is all that I had. So I made it very brief for you, just on that particular criteria of the special exception.
Mr. Chair, if I could ask just one question to clarify. Ms. Stevens, thank you. Could you point me to any place in your technical materials that contain drilling logs deeper than 15 feet at the site?
In the drilling logs deeper than 15, I believe, no. The GSE report, they did go to 15 feet, and we have somebody from GSE here to get into more specifics, because I haven't memorized that, but they do have drilling logs are in that GSE report.
Right.
The logs are in there, and there are 27 of them all over where the stormwater basins will be, which is the entirety of the Terra April.
Right, and I just want to clarify for the board so they understand none of them went deeper than 15 feet. And I'll leave it to the experts to tell us what all that means, but I wanted that fact on the record.
And to clarify on that point is the basins are significantly the stormwater basins are significantly shallower than the by I think at least 10 feet, maybe a little less than the borings. I mean, the borings went significantly deeper than the basins will be constructed.
Okay, and then the materials that pertain to, I think it was on another slide, some geophysical investigation that was not on this site.
Oh,
correct?
I was trying to order this in order, and then I left out the Wood report. I wanted to point out we did have the Wood report, the Water Quality Improvement Project report, which is cited by many people as if it's new. It came out exactly the same time as Wood was reviewing the Verde environmental assessment.
But I'm asking about the Wood report as it relates to the Mill Sink project, which is not on your site.
Correct.
That's
correct.
What I want
it is
the
not.
board
Yes.
to
Yes. To clarify, that is not. I was trying to organize it in my notes and talk about that last, and I skipped right over it.
And then you would agree with me as a lawyer that the city has concurrent jurisdiction over stormwater, correct?
Oh, absolutely. Yes.
Okay. So you do have an ERP permit. That is significant for the board to understand. The master plan could be changed, could it not, to accommodate findings from further geophysical work, correct?
If we were to need to I'm not quite sure. The master plan, yes, could be changed in terms of the infrastructure plans approved by the Water Management District. If they were significantly changed, those would require a modification of the ERP.
But you could argue the materiality and whether a change was needed if that occurred with the Water Management District. So we don't know tonight if that's the case, but it's possible to amend those as well, correct?
Yes.
Okay. I just wanted the board to understand the procedure a little bit, because there's a lot of material in the record. Some of it has a little hair on it. So thank you so much.
Oh, sorry. And I'm going to turn it back over to Ms. Gadelia to wrap it up here.
I probably will not be able to be brief on this point. You've heard all of it, and we believe we meet the burden, and we have demonstrated that we satisfy the criteria. I want to talk, though, about the condition that was offered by staff based on Mr. Alfieri's extensive work. You should have up there a page, I think Ms. Brenda put them all up there, that outlines 6 paragraphs, the way of trying to document the condition that staff is proposing, but with just a little bit of a modification with regard to the sequencing of the study. So to be clear, the applicant is agreeing to do the work that the city, based on its experts' analysis, has asked it to do. It will do the work. We have a proposal that's a little bit different. It's not quite clear because the way that the tasks are outlined and that Mr. Alfieri presented and board member Judd did go through and say, is this specifically what you had in your report? But we don't have the conditions written out so very crisply. And so, we got this a week ago, as you know. We understood that this was a thing that was in process, but we received the condition, the letter, the proposal by staff that the conditions apply not just to April, special exception, but to Phoenicia's infrastructure plan, to April's infrastructure plan, to Terra Forest West's construction plans, so series of plans. And then we waited and we received Mr. Alfieri's analysis that he presented tonight, yesterday. We certainly did not want to continue the proceeding because of the significant angst that developed the last time, but we wanted to be thoughtful in allowing the folks that we're going to be hiring to do the work that the city wants us to do, and our stormwater engineers to talk to Mr. Alfieri, understand how this all works, and figure out the plan moving forward. So what we're proposing, in order to give us some flexibility in the phasing of this work, are the 6 provisions that are listed on that page. Ms. Boyes, do you want me to just read through them?
I think
how should we address this?
I think it's great that you announced it so the board knows this is coming. Would it be okay with you if we did the iteration after staff puts
Yes.
the recommended condition on the record, and then you can react and the board will be fully apprised of all the presentations?
Absolutely. Agree.
Okay. Thank you. And then may I ask, are these 6 conditions you are proposing in lieu of the 11 that staff's proposing, or in addition to, or will you be able to walk us through that later in the hearing?
Yeah, so the entirety of the conditions that Mr. Speaker went through in his analysis, which I believe, I'm trying to think of your list there, would be, is that the 11 that we're talking about, or is there more or less?
Staff has proposed 11.
Yes.
9 and 10 deal with the recommended geotechnical, or I'm sorry, hydrogeologic work, and then the acknowledgement that additional engineering may be necessary depending on the outcome. Are these like 9A through
Yes.
A, B, C, D, F?
That would be the appropriate way to
9A through F, is that how we should understand it?
Yes, that's exactly how it should be understood.
Okay, I would greatly appreciate on behalf of the board if we come back to this later so they have time to look at this and think about it.
That makes perfect sense.
As well as the public.
Thank you.
Thank you so much.
Chair, I see a number of people, including our county commissioner, Mary Helen, standing in the back and alongside. There's chairs that are open in the area here, so in the main seating area. So if anybody maybe if somebody could let the folks know in the lobby that there's seating available. We're not done yet, and so standing another hour or so is probably going to get a little wearing.
Thank you, Mr. Chair.
Mr. Chair, we probably should have done this at the beginning of the hearing, but I'm sure the board and the chair would like to welcome our county commissioners, Mary Helen Wheeler, Ken Cornell, and Chuck Chestnut, who are here. And I know we have the mayor, Alachua. I saw him earlier. And are there any other elected officials that I can't see who are here with us? Anyway, we welcome you and apologize for the seating.
Yes, welcome.
One other procedural question. This is more for Brian. How are we keeping track of the exhibits that have been referred to? Everything's in evidence already with our Madam Clerk, or how is that working?
I believe everything that we have is already in the record, other than the additional 6 conditions that are being proposed by the applicant.
So the materials that Brian offered on behalf of the city, in addition to, the list that's in your code, which is includes the comprehensive plan, the land development regulations, CVs of professional staff for the city, all of the presentations that have been submitted by the applicant. I would ask if copies of all of the documents that Ms. Stevens referenced in the 2 slides were submitted, just to confirm that for the record. And if not, if she could provide copies to the clerk. And then there are presentations that have been submitted to staff by the 3 proposed affected parties. And there is another professor, and I'm not sure if the county is sponsoring his materials, but he could not be here this evening. There is a slide deck, so we'll leave it to the county as to whether they're moving that into evidence or not. So I would just ask the affected parties, when you come up, since we have a court reporter, to make it easy to read the transcript later, that you give us a list of exhibits you're offering for evidence. And so at this time, we're ready for the proposed affected parties presentations, which we'd lead off with the National Speleological Society. I know council's making her way to the podium. Ms. Jane Graham. And I would just ask her to introduce her team. Then if the witnesses would indicate when they come forward, introduce themselves and indicate if they've already been sworn, please, for the record.
And also, Mr. Chair, just would like to point out if the board would bear with staff a little bit working in the back room, because we have got a number of presentations that have been presented. And so there'll be a little bit of shuffling around to get the right ones up at the right time.
So the first order of business, Mr. Chair, would be for you to decide if this proposed affected party should be admitted to the quasi-judicial hearing and then be allowed to present testimony.
Very well. The chair recognizes excuse me. Say it for me.
The National Speleological Society.
Speleological. Thank you.
Excellent. Thank you. And I guess I'm waiting for my presentation to come up. This would be Jane Graham's presentation, if you have it.
So we will admit you as an affected party.
Great. Thank you very much. And before we get started, if we could clarify, we've requested a total of 30 minutes presentation time, 10 minutes for myself for legal arguments, and 10 for Stephen Boyes, and 10 for Sawicki and Ken Sallet. I believe he's someone that we've added, so maybe 3 to 5 for him, if that's all right.
Please proceed.
Thank you very much. All right. Good evening. My name is Jane Graham of Sunshine City Law in Tampa Bay. I represent the National Speleological Society. Today with me as experts, I have Stephen Boyes, who is a hydrogeologist with decades of expertise in Mill Creek Sink, Professor Sawicki, a subterranean biologist and professor at FAMU, and Ken Salat, who has observational experience and expertise in Mill Creek Sink. We respectfully request tonight that you deny the Terra April exception. The applicant has the burden to prove with competent substantial evidence that it meets the criteria for a special exception, and they failed to do so on at least 4 of the criteria. Most significantly, the application is unsupported by adequate data and analysis as to the environmental impacts and compatibility with neighboring land. While there is a new proposal on the table tonight by the city to perform testing, the answers need to come before you vote tonight to allow this to move forward. We also, for the record, object to the 6 conditions that the applicant has suggested that they'll provide, but they haven't shown it to us so that as affected parties, we are not able to even respond to what those are. There are lives and property at risk, and it should not be gambled with. Okay. I don't know why this isn't working. That is really strange. Okay, so who is the National Speleological Society? The National Speleological Society is a nonprofit membership organization dedicated to the scientific study of caves and karst, protecting caves and their natural contents through conservation, ownership, stewardship, and public education, and responsible cave exploration. On top of that, they are an abutting property owner to the proposed Terra April site. And so they are a uniquely affected party which suffers special injury by the introduction of stormwater areas into the karst area. And NSS will suffer, so both as a neighboring property owner with direct impact to the value of its property, as well as organizationally through harm to the cave system and the members' opportunity for safe cave exploration. So section 2.4.4D contains the standards to be met for a special exception, and here it clearly doesn't comply with 1, 2, 4, 6, and 8. Without me going into great detail, you will hear tonight testimony from Professor Sawicki on the subterranean biology of the area to explain why the design does not minimize environmental impacts, and that he finds that it poses a substantial ecological risk. You'll hear testimony from Stephen Boyes, who has decades of experience as a geologist and expertise in Mill Creek Sink, who will testify as to how it poses a significant geological risk and is incompatible. I will speak to some of the other land use issues as well, but I'd like the experts to testify first. So I'll come back after this. Thank you very much.
Thank you.
Ms. Graham, well, we just received these this evening from Ms. Godelia. Casting no aspersions, but we're having copies made of the 6 conditions.
Okay, thank you.
That's really
very
why we're
much.
trying to move that to the end so everybody has a chance to review it.
Yeah, it's just there's a concern for
Of course, of course.
Because okay.
Thank you.
All right. I guess for IT, if we could get Stephen Boyes' presentation up, please. Oh, if we could get Stephen Boyes' presentation up, please.
Okay.
Good evening. I'm Stephen Boyes. I'm a licensed professional geologist in the state of Florida, license number 184. I've lived in Alachua County since 1986. I have practiced geology and hydrogeology, environmental law, testimony, and I've been around this area for a long time. The PG seal on the dye trace investigation, where we put dye in the sink and it showed up in High Springs. It's a wonderful book. Sam Upchurch has created this with the adjacent authors, and it's a reference that is readily important to this and should be on every planner's desk in this county anyway. My review of the special exception permit to allow placement of a minor utility stormwater management facilities indicates insufficient information has been developed by the applicant to support the permit application for a stormwater plan. There's a cross-county fracture zone that's been published. Starting in 1951, Vernon mapped Central Florida and major fractures in Central Florida. Highlighted in yellow is what has become known as the cross-county fracture zone on this figure. And this shows all of Central Florida. That's a rather substantial feature. It stretches beyond Alachua County, but through the entire width of Alachua County. It's okay. Okay, this is the publication in 1977 by White indicating the location of the cross-county fracture zone in Alachua County. It's approximately a mile wide. There's a lot of fracturing that goes on in it. It's more or less the limestone platform broke, fractured. And within that zone, there are lots of breaks. The photolinear map you recently saw. Okay. Okay. The intersection of multiple fractures is typically the location most likely to experience subsidence and collapse. This is what is apparent in the area of the proposed stormwater basin plan. The area proposed development is not just high risk for subsidence, it's very, very, very high risk for subsidence and sinkhole development. Changing land use drainage patterns will dramatically increase the risk of subsidence. Collapse in this area could create life-threatening conditions and in and around I-75 and I-75 entrance ramp, as well as any divers that might be diving in the cave system at any particular point in time if a subsidence takes place then. It's the movement of water and forced infiltration of water that is the most common trigger of subsidence in karst terrains. Geologically infilled karst features like old filled sinkholes and vertical solution tubes plug are typically locations for subsidence caused by forced infiltration of water. That is why you investigate subsurface conditions before you select the location for infiltration. You have to look and investigate before you can locate, design a basin. Okay. I have two figures from Sam's book. Cover collapse sinkholes I call them alluvial dolines, form as a result of sands and clay sands being flushed, raveling into the cavernous holes in the limestone. The driving force is gravity and hydraulic head. The forced infiltration of water drives sediments further into the underlying secondary porosity of the limestone, the caves. This is not just an issue directly over the overlying the karst features, the vertical solution tubes and infill sinkholes. It can also impact filled karst features laterally some distance from the basins. This is the concern for I-75. Buried karst features resulting in the mobilization of sediments and their migration further into the cavernous porosity of the limestone some distance away. So where are the sinkholes? This is a figure from the text indicating the void that sucked it up was laterally. The bulk of the karst book was developed investigating subsidence of houses and whatnot. But in this case, I wanted to make the point that subsidence can occur not directly through the basin, but also out from the basin if water is being rooted down in that direction. And you don't know what's in the subsurface. If you don't look, you don't know. This is the 1962 topographic map. The interstate was drawn in on top of the existing topographic map. On this figure, you can see a wealth of sinkholes present. Dr. Upchurch has mapped sinkholes. Okay. Dr. Upchurch has mapped sinkholes in this basin and calculated the volume of sediments that have migrated into the caverns in Mill Creek Drainage Basin in geologic time. A figure from Upchurch clearly shows the location of karst features in the area of the proposed stormwater plan. The karst features are mapped, outlined in red, are numerous. The calculation, which is in this sidebar for a book he's writing, indicates that over geologic time, 12.6 million cubic yards of sediment has washed into the underlying limestone. That's 634,000 20-yard dump trucks. That's what's gone into the ground that this cavernous system has sucked up already. Lots of sediments in the subsurface environment here, and a lot of buried karst features. Drinking water quality. Stormwater recharge, collapse, and subsidence is a significant risk to water quality in the Floridan aquifer and its caverns. Not simply just silting, but impacts to water quality. Recharge water entering the ground will be the source of drinking water supply for wells located down gradient of the development site. High Springs receives its water supply in a matter of days, not years, from this location. Cavernous flow of groundwater provides no significant level of treatment to the water. Oh, I got the wrong one. Okay, this is a blow up of that map, and this shows the area mill sink. And of real concern here are everything outlined in red are sinks that Sam has mapped, and that includes the entire basin in the immediate vicinity. Here's I-75 coming up here, and this is where you're planning on putting this thing. There's a lot of buried a lot of buried karst. It's expected. Anyway, to sum up, in conclusion, and I guess I have made the point, but Mill Creek caverns and sinks are a significant geologic feature. It's not minor, it's significant. Additional investigation is required before a stormwater plan and design can be located in the area. You need to not put the stormwater basins on any buried sinkholes or vertical solution tubes. You have to look for these things before you place the bottom of this pond there. They don't know what's there. My experience, unfortunately, is in this particular area, it's going to be a real challenge, but you got to look. You can't put the cart before the horse, and you can't make a silk purse out of a sow's ear. Any questions?
Questions?
Could you put up the presentation for Tom Sawicki? I believe it just says Alachua. Unless Jane changed the name.
That's it. Hello, thank you for having me. My name is Tom Sawicki. I'm here tonight to talk to you about the biology of the Mill Creek system. Before I do, just introduce myself a little bit. I'm currently an associate professor of biology at Florida A&M University. I've been there since 2014. I have almost 30 years of experience diving in and exploring, both as a recreational aspect as well as a scientific diver in cave systems across the world. I've described new species from caves from Bermuda to Palau. But the last 15 years, I've been really focused on the Floridan aquifer. I don't know if this is going to work or not, but let's see. It does not. Could somebody click on this? It's a video. I was hoping to play this. Yeah, it's play button. Thank you so much. This is the Devil's Ear Eye Cave System in Gilchrist County. This I want to show you this because I want to give you an idea of what it's like to be in these systems and to dive in these systems and try to explore and do research in these systems. I was in this particular dive doing an investigation for a microbial ecologist. I was looking for microbial mats in the system. And right about now, well, maybe in a little bit here. Yeah, is this working? Nope, not working. Oh, well. In a little bit, what you're going to see swimming by is an amphipod crustacean. It's a little white speck moving through the water. And there's going to be another one that's going to move through here shortly. It's hard to see it from this vantage point. But that kind of makes the point. These systems are really difficult to study. I've done dives in the system multiple times, never seen anything, and then come up with a brand new species that has, again, never been seen before. Because they're very, very difficult to track. We don't know where they go. We don't know where they spend most of their time. It's not usually in the big solution tubes that a human can fit, but they're there. I point this out because, as far as I know, there's only one publication that lists the biology of the Mill Creek system. It's a paper that was published in '94 by Richard Franz, Judy Bauer, and Tom Morris. And in this publication, they note that there is Procambrus pallidus, a cave crayfish, and some unidentified amphipods, which on the surface makes it seem as if there's not a lot of biological diversity in the system to be concerned with. I want to point out a different cave. It's a cave called Herzog Cave. It's located about 10 miles or so due south of the Mill Creek system. And in that same publication by Franz et al., they know only 3 species of cave crustaceans in this particular system. Procambrus pallidus, Troglocambrus macklini, and an amphipod crustacean, Crangonix grandimanus. Now, I'm going to point out Crangonix grandimanus just a little bit here. That is an amphipod crustacean. That's my area of expertise. I also work on isopod crustaceans. In 2018, I asked Paul Moeller of the Florida Fish and Wildlife Conservation Commission to do some collections in there for me for some research that we were doing. And when he did this really cursory collections, we more than doubled the biodiversity in this single system, discovering microcrustaceans, another amphipod, Crangonix hobsai, as well as an isopod, Cicododia hobsai. In other words, there's a lot more diversity there than we first thought. And just kind of having a little aside, in 1994, there were only thought to be 2 amphipod crustaceans in the entire state of Florida. The research that my lab has done in the last 10 years, we've described another 6 species, and we have at least another 2 to 3 that we're currently working on. It goes even deeper than that, though. That Crangonix, let me go back, the Crangonix grandimanus and the Crangonix hobsai, the 2 amphipod crustaceans that can look like little shrimp things there, they were thought to be broadly distributed across the entire state of Florida. This is a distribution map. The circles show where the Crangonix hobsai and grandimanus populations were supposed to be. It's a small world. There's not a lot of people who do this work. John Holsinger there, he was my PhD advisor. Jun Zhang, he was my lab mate. So I happen to know these guys that did this work. And I remember when June did this, I said, man, I don't buy it. I don't see how it's possible there's just a single species or like single distribution of these two species across the entire state. The problem is gene flow. These things live in caves. They don't have eyes. They're not going to swim outside the cave, go down the stream, and then go to another cave where they can then reproduce and exchange genes. And so there's going to be a lot of isolation and potential, therefore, for what we call speciation, the evolution of species. So when I began my work here, 10, 15 years ago, we began collecting these organisms and looking at them genetically. The work June did was all morphologically. They look fairly similar. They look similar enough to call them all the same species. But what we discovered is that, in fact, there are multiple species within these two complexes. They're separated primarily by the Suwannee River Basin and the Santa Fe River Basin. We ended up describing the Hobbs-eye complex so far into two different species, but I want to point out there's actually a third potential species sitting there. You see that light blue area with the question marks? That's likely a local endemic. We only know them from two locations, the Newberry Bat Cave in Alachua County and Indian Cave in Marion County. It's possible they're elsewhere. You'll notice how close the Alachua Cave, the Newberry Bat Cave system is to Mill Creek. It is possible that in Mill Creek there is a local endemic, and likely highly threatened species in that system, and we just don't know. This is the same pattern for Crangonix grandimanus. We have not completed the work on this, so it's still a single species, although I'm actually writing the paper that will separate one species into two, and there's actually likely three. And I want to point out the white triangles. You notice it's the same pattern for the grandimanus population as it was for the Hobbs-eye population, something very unique there. I want to switch gears very, very briefly. My colleague was just talking about groundwater and drinking water and how important it is. We have known for a very long time that microbial community is extraordinarily important in terms of energy production for cave systems. There's no light down there, so there's no plants growing. There's nothing for these animals to eat. Where the energy come from? Well, there's stuff we call Locthinus detritus. This is organic material that washes into the cave periodically, and then microbial organisms break that down and make it available to the other animals that live in the system. And additionally, there's some microbes that can do what we call chemoautotrophism. That is similar to photosynthesis, but it's chemosynthesis. They can take the energy of chemicals, inorganic chemicals, and convert that into the energy of organic chemicals, sugars and proteins and that type of stuff, making it available to the rest of the ecosystem. But what we're learning in recent research, the last decade or so, is that these microbial communities are also extraordinarily important in the purification of the water. When I was in graduate school and I took a course in cave biology, we talked about vadose water, the movement, the recharge, the movement of water through the ground and being filtered by sand and that type of thing, cleaning the water. But we're now learning that it's actually the microbial community that has a really important function in terms of cleaning the water. So if you have polluted recharge going in there, what that does, that introduces contaminants, introduces pathogens, and it introduces antibiotic-resistant genes into the groundwater. This affects the microbial community. It affects its ability to keep the water clean. And of course, that's going to then rebound up through the trophic structure. We don't know what's happening until you see changes in the community structure itself, changes in the amphipods and the crayfish that are in there. So in conclusion, I want to point out that the published literature that's out there for the Mill Creek system likely severely underestimates the biological diversity that's actually there. I also want to point out what we suspect is there. Procambrus pallidus for sure. Unidentified amphipods, probably Crangonix grandimanus and Hobbs-eye, but potentially, again, a very new and localized endemic species. They're listed by multiple agencies as imperiled or threatened. I also want to point out the importance of the microbial community for the purification of the groundwater for your citizens, the citizens that are drinking this water. Additionally, Section 2.4.4 D4 states that there's a require for the design to minimize environmental impact. Our geologist friend earlier was talking about you need boots on the ground to know what's going on. Well, for a cave or water-filled cave system, you need fins in the water. We just don't know what's there. I've actually tried to dive the system once. And again, I've been diving in Florida for 30 years. I tried to do it only once. I wasn't able to get in because the conditions were so poor that day. The visibility was zero. So it never cleared up. We were hoping as we got in, it would clear up and I'd be able to get in and do the dive, just never did. I believe the data I presented here today demonstrates that there's not sufficient understanding of the biological diversity in the system to say that they've been minimizing impact. We don't know what the impact is because we really don't know what's in this system. And those are my references for this. If there are any questions, I'm happy to answer them.
Members, do you have any questions?
Thank you so much.
Mr. Chair, I have just one.
Ladies and gentlemen, please do not applaud.
Dr. Sawicki, just a real quick question.
Sorry, yes, ma'am.
No worries. How deep is the Mill Creek cave system?
My understanding is a couple hundred feet deep.
How do you know that?
Ken may be able to speak to that better. Well, I had wanted to dive into Mill Creek for a long period of time, and for a long time you needed a guide. You just can't go there and dive. And so I finally got a guide, and of course that day the conditions were bad. But going into the cave, I had to prepare for it, right? So I had to know the depth, and so you had to mix your gases and ahead of time for that level of depth. You have to reduce the amount of oxygen in your tank, and reduce the amount of nitrogen by adding helium to the gas mix.
Kind of cutting to
Sure.
My question was just how deep is the cave system?
200 something feet. I don't remember exactly. That was a while ago.
Okay, and I think it's a fact important. We'll let the applicants, experts, and other experts tell us if that's significant.
Yeah. Thank you.
What do we got here technology-wise? My name's Ken Sallet. I am a resident of Alachua County. I'm also a dive guide at Mill Creek Sink. If you can bring up my PowerPoint, please, I'd appreciate it. My first dive at Mill Creek Sink was back in 1995, so I've been there over the years. I've been guiding divers there for the past 5 years. As Dr. Sawicki had mentioned, it does require a dive guide. One of the reasons is because the visibility in the system is fairly complex at times. It's seasonal. What I'm here to talk to you about tonight is to give you a little bit of a snapshot of what you can see when you go diving in the system, so you have an idea of what the cave actually looks like. So I'd like to start with a little bit of an overview of a map. This is the map of the cave system that has been mapped by divers. These are places that we've gone into. How do I get the laser pointer to work? Yeah, I think I've got the separate one. You know how this works? It's weird.
Actually, I think it's the other one.
This one? Okay. No, that's the other way. I want to bring the laser up. Yeah, what I was trying to show you is right over by the Sunnies. Do we have a laser pointer there? It's a little pen. Oh, got it. Okay. So the entrance to the cave system is right over here, right at Mill Creek Sink itself. And if you notice, it looks like a funnel. I think that's an important distinction to think about when you think about funnels draining down into things. Right on the north of that, this little passage right there is underground, and that goes to where the Mill Creek Swallow is, where Mill Creek itself goes underground, just so you have an idea. From the Mill Creek Sink, it descends down to a depth of about 150 feet, and then we have what we call an upstream and downstream junction. Heading south from Mill Creek is our downstream tunnel. The average depths in there can average anywhere between 100 feet or so of depth to about 220 feet all the way down at the terminal end, where the divers have been exploring. And I have been down to that terminal area. We come to little fractures in the cave where we're unable to actually pass through. I'm a pretty big boy. I can't fit through any of those small holes that are down there. Upstream of the cave system from this junction point, we have our very first room. This is a room we call Dana's room. And the depth of it is 150 feet at the depth, but the ceiling is 60 feet tall. Let me put that in context for you. That's a 90-foot vertical relief in that void. On top of that, this room is probably a good 100 feet in diameter, and there is one of the most unique clay formations I have ever seen in over 30 years of cave diving in there. We have a sheer wall that goes from 140 feet all the way up to a depth of 90 feet of these beautiful stratification layer of clay and silt, and it's a very unique feature that is right inside of there. Once we leave Dana's room, you go upstream in towards where the Lowe's is. We have an average depth here of between 150 and 120 feet. It goes up and down over and over in an area that we call the roller coaster. Once we pass the roller coaster, we come into our second of the major rooms. And I'll talk about that one a little bit because I've actually got a video of there. The ceiling in that room is at a depth of about 60 feet. And once again, we have this debris cone that sits there at a depth of about 90 to 100 feet of depth. And then it gently slopes down into descending little passages from there. This next stretch here is at about a depth of 150 feet. Then from there, it drops down to about 180 feet. And then this area here on password is a depth of between 200 and 230 feet of depth. One of the things that divers have to consider is that whenever we are diving, we're under pressure from the water. And those extreme depths also mean that we have to release the nitrogen and helium that our bodies absorb while we're diving in a process that's called decompression. So exploration in this area here involves several hours of decompression. My most recent dive was right before Christmas break over there, and we spent 3.5 hours doing decompression in Mill Creek Sink because we had a 2-hour bottom time exploring in this region right around here. If somebody could play the video, this video is in the second room, and Mr. Boyce had mentioned that there are solution tubes inside of some of these caves. We found this feature actually just in November. And what it is it's one of these solution tubes that's right in the ceiling. The ceiling is at a depth of about 60 feet. And this little solution tube is too small for a diver to fit in. But if we can get the video running, you'll see that we're actually able to stick a GoPro up there. And you can see that there's a little bit of a void and an opening underneath there. And that is in that second room.
I believe they're having trouble getting the video.
Yeah. Any no-go? Okay. Well, there is this little solution tube in there. This is in that first room that I was telling you about. What we have is a diver sitting right at the top of that clay bank that we're talking about, and then the photographer is sitting about 20 feet above them. As you can see on either side of it, we've got the clay formation dropping off on this side and dropping off on the other side. I just cannot tell you the size of this room and the scope of it. This auditorium would very easily fit inside of that one location. I've guided at least 6 people that are here in the audience tonight. If you all agree with me on that, please raise your hand. This is another one of those rooms, and you notice that you can't really see a lot of what is going on in there, and that's just because of the immense space that's inside of this void. Remember, I think it was Dr. Sawicki that mentioned something about the flora and fauna, or the fauna down there needs to use chemosynthesis. In other words, they need to use the chemicals in the water because there is no light. We as divers have to bring our own lights with us. And unfortunately, this room is so big, we cannot bring enough light in there to properly illuminate it to really get a good photograph. Another thing I do want to mention is that this cave has been featured in news articles and magazines such as Underwater Speleology. This section right here on the cover of this magazine is in the downstream passage. It's an area that we call the subway passage. It's at a depth of about 160 feet. It's a solid 10 feet in diameter tube. It almost looks like a worm has eaten through the limestone there. It's one of the most amazing features anybody has ever seen. All of us that have been down there say, oh, wow, that is absolutely incredible. And it's a very unique feature. One of the things I did want to mention, I'm going to go back to a couple slides here with the map. When I was talking about the funnel, everything that comes in right here into the surface strength of the Swallet does go downstream. In the downstream passage, just a couple hundred feet from where that junction room is, I have found beer cans, I have found bottles, and it is frequently getting, any sort of debris, any sort of thing like that goes down there. And as has been previously mentioned, Mr. Boyce has run a dye trace on there back in 2005. And the water that is coming through there goes downstream and then comes out in High Springs within 12 days. So it's something for you all to consider because that is the water we do rely on here in Alachua County. And so, just food for thought. Thank you for your time. If you have any questions, I'm happy to answer them.
Members, do you have any questions? My question for you is, when you talk about the depth being 100 to 200 feet deep, how far is that from the top of the ground above you? Is that the 200, 100, 200 feet, or is there additional
Yeah.
dirt above that?
No, that's a great question. And in all honesty, I am not qualified to answer that. And the reason is because our gauges that that tell us our depth are actually just reading the pressure that our bodies are under.
Gotcha.
If we took a 1-inch column right here on the surface of the Earth and went into outer space, it weighs about 15 pounds for that square inch. And every 33 feet of seawater is an additional pound of or additional 15 pounds of pressure. There are many different things that can impact that. The weight of the rock above us can impact it. The only way you really can tell is by doing some ground penetration work on that. And I'm not a geologist, and I didn't sleep in a Holiday Inn Express last night, so I can't get into more details on that.
Thank you.
Mr.
I
Chair.
appreciate it.
Mr. Chair, if I may, if you could kindly let me know if you, first of all, took any of the photos you've shown tonight in your slides. Did you take those photos
The
and
video, the video I took, or Brian did with me, and the second photo of the thing was taken by my friend S.J. Bennett. She is a professional underwater photographer. And then the third one was taken by a guy by the name of Jimmy Godomsky, who's also a professional.
Okay, but I asked if you took any. So
no, I didn't.
Okay.
Yeah.
And then of this map we're looking at with the blue, whatever, did you make that map?
That map was made by researchers with Carson Underwater Research. We're a volunteer organization. We've collected the survey data and made that map over the time. It's also been
Hold up. Did
Sure.
you make the map?
The map was created by a friend of mine by the name of Andrew Pitkin. He is the head of the Dive Guide program.
Okay, so that's a no.
No.
Okay, I just want to make the record has got to be clear for the board. So
Sure.
we don't want to over or underrepresent. We want to be fair to all parties. So we
Certainly.
want to clarify what evidence you're offering and your authority to do that. So I mean, no
Certainly.
disrespect. On this cave map,
Mhm.
has a human traversed the entirety of the blue line?
Yes. Every bit of that blue line that is on that map has been surveyed by a human with a compass and a tape measure. And the other element about it as well, in a couple of locations,
I mean, has it been?
Yes.
What's the word? GPS located so that
We've done that too.
the applicant could
So yeah.
So the applicant could correlate GPS locations if they had your layers and metadata to their property? Because I'm not seeing
I
that
can't
high.
speak to the technical competencies of the applicant, but what I can
I
tell
didn't
you.
ask you that.
Well, you asked me if the applicant can
I
layer
asked
them.
you if they would be able to evaluate your blue line if they had access to the metadata.
I can't speak to their technical competency if we gave them the metadata. But
You have the metadata to provide is what I'm asking.
we will provide it.
Okay, and would you provide that to the city, please?
I will ask Andy to take care of that.
Okay, and that's probably the wrong term, but if it's a KMC file or some type
Yeah,
of electronic
KML.
file
KML.
thank you, that the experts could then use, both the applicant's experts as well as the city's experts.
Certainly. And I do want to comment on that. In this area right there, right where I highlighted with the laser, back in about 15 years ago, I believe there was a plan to put a Walmart on site. And so we used a cave radio location device to validate those locations. So we actually put a magnet in the
Say
cave.
what did you do?
I was not directly part of that, but I meant Karst Underwater Research. I'm speaking in the holistic sense.
Okay. All right. And then you've personally been in a portion of this blue cave? Just
I
want to
have
clarify for
been
the
up
record.
to about that location, and I've been all the way down to there and everywhere
Going
in
in
between.
at Mill Sink and going both directions?
Yes, ma'am.
All right. And I guess it was unclear to us if Dr. Swicky has actually been in the cave.
From what I heard of his testimony, he is not, but I cannot speak to him on that.
Okay. We'll just ask him later to come up and clarify.
Sure.
All right. Thank you.
Yep. Where do these go?
Mr. Chair, I have a follow-up question real quick, which reminds me of something from Ms. Boyce. I think it was the 2006, maybe somewhere thereabouts, Walmart development agreement that dealt with areas similar to this. I don't know if it was the exact same parcels, but what data and analysis, was collected by the city at that time? In other words, is any of that germane to tonight's conversation? And that may or may not be something you can answer right now.
I can promise you I did not work for the city at that point. I don't think anybody at the dais did, but we could look into that when it,
The reason why I bring it up is I was, I think, with the city in that approximate time. And as I recall, there was a lot of discussion about this general area. There was a lot of expert testimony brought to bear. So I don't know, you know what I'm saying? And if any of it is germane to this particular area, I think it would be of interest to all parties that whatever data and analysis was included in that, has it changed? Has it remained the same? That type of thing. So anyway, thank you. I appreciate that.
Sure, Mr. Chair, if the board wishes, if the board ends up being inclined to approve the special exception and adopt the conditions suggested by staff, I'd recommend that that material be pulled by staff out of the archives and provided to the experts for the applicant, the city, and for further evaluation as that hydrogeologic work is done. But that's a good point.
Yes, very good. Thank you.
Thank you, Chair. So to follow up, I think first of all, Member Judd makes a good point that there is some additional information in the record, and it's not something that should be a fait accompli that you approve it and then look at it afterwards for the city hired expert. It's something that you, as members of the Planning and Zoning Board, have the right and the duty to have in front of you presented with the burden by the applicant to show that. And it's their burden to prove that they meet all of the criteria. And so at this point, I'd like to go through the criteria under section 2.4.4D and highlight some of the areas where they specifically fail to meet those criteria. So first of all, under 2.4.4D1, this is compliance with use-specific regulations. The staff report analyzes this application through the lens of a standard of a minor utility. Now, 10.2 defines a minor utility as infrastructure services that need to be located in or near the neighborhood or use type where the service is provided. Here, you've got a big problem because the use type is unknown and at best speculative. It says in the staff report that this is to allow the placement of a minor utility stormwater management facility in the agricultural zoning district that could potentially support future development on adjacent land zoned community commercial, which is CC, but you don't know exactly what those uses are. And while they have given you a list of what they cannot be, you don't know what they actually are. Now, given the Live Local Act, it could potentially be high-density residential, which means that the density, intensity, range of uses, and needs are undefined and vague. And so characterizing a stormwater pond as a minor utility fails on its face because it's unknown as to what exactly it's providing infrastructure services for. Now, you've also heard tonight that, well, this is for FDOT stormwater treatment, but I haven't heard anything from FDOT tonight, and you will be hearing from the county more about that, where it appears that FDOT does not believe that this is something that is needed given what has already been approved for FDOT. So I will leave that for further in the hearing for you to learn about. Now, Section 4.3.214A requires a minor utility to be located within a reasonable proximity of the area to be served. But again, here, since this project is potentially supporting future development, we don't know what it's providing benefits for. And actually, we understand that generally it is for other Terra projects. But how can we evaluate whether it is in reasonable proximity of the area to be served? These are unanswered questions. This is where they have the burden as applicant to prove it, and these are just wide gaps in your knowledge. Section 2.4.4D2 is about a demonstration of compatibility. And now the staff report says that the stormwater facilities are compatible because they include a series of walking trails, which are relatively passive, that are compatible with the uses in the surrounding area. Now, they're right that compatibility is defined as a condition in which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time. But in this case, I would say that walking trails is not the right question to be asking when it comes about compatibility. When you've heard testimony tonight from Stephen Boyes that this is very, 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 very risky as far as the impacts of potential catastrophic impacts on the cave. Assuming that stormwater treatment is by nature compatible really belies the exceptional situation that we are looking at tonight for Mill Creek Sink. You need to have these answers before you approve this tonight. You don't have these answers. Section 2.4.4D4 says that it must minimize environmental impacts, and the staff report admits that additional data will be required. Now, they punt to the infrastructure plan for minimizing environmental impacts, but we argue you cannot punt to the infrastructure plan when the subsurface impacts are so critical. And the fact that the city has spent their own money, and I think that was a good question of who's spending money on this and for what. What is this for? And Dr. Sawicki has explained that these are very unusual and rare biota within the caves, and it's something that needs further explanation and exploration. Section 2.4.4D6 is about injuring neighboring land or property values. Now, the staff report says it's not anticipated that it would have a substantial impact, which would injure the use to neighboring land, but National Speleological Society, which is a neighboring property owner, their property and its value is completely contingent on the continued safe use of the Mill Creek Cavern and the cave system for its members and tourists. And so without the information, it's impossible to know whether impacts to the cave system are going to injure the land or not. And, this is something that the NSS would not want to find out after the fact because it would, in effect, destroy their property. Finally, it does not comply with other relevant laws and ordinances. I would just draw your attention to the City of Alachua Comp Plan Objective 1.7, Geological Resources. The city shall identify, protect, and conserve significant geological resources and their natural functions. As Stephen Boyes has said, this is an extremely unusual and special geological feature that needs to be protected, and you can't approve it and then find after the fact, oh yeah, we can't do this. That's a bad idea. So without this information in front of you, you cannot approve this tonight. I'm going to be providing into the evidence a list. It's in this box. It includes the National Speleological Society property deed, the Alachua Property Appraiser's website of the NSS property in relation to the April NSS's mission statement, and the Mill Creek Sink Nature Preserve Management Plan, various letters that are within here, as well as the resume of Stephen Boyes, pictures that are referenced by Steve Boyes, USGS map, the Mill Creek and Lee Sink's dye trace report from July 2005, Thomas Sawicki resume and his letter and presentation. I thank you, and we appreciate the opportunity to share our perspectives. We really do appreciate the time that you've given National Speleological Society tonight to be able to present this. I'm here for any questions, and I didn't say this beforehand, but just by way of my background, I am board certified in city, county, local government law. I've been practicing for 16 years exclusively in land use and environmental law, and I have a environmental LLM from Vermont Law Society, Law School, which is the top-rated environmental school. So thank you very much.
Thank you. Members, do you have any further questions? Okay, thank you so much.
Thank you very much.
Ladies and gentlemen, at this time, I'm going to recess for 10 minutes. I think we've had quite a bit going on here, so we'll come back in 10 minutes and re-adjourn. Yes, sir. Time to stretch them out.
It's filling up with the. I appreciate it. Yeah. That's why yeah, that's why I'm stuck in the back. Because I have, yeah. Yeah, I told my dad to stack to need like 4 o'clock. Yeah, I had a full good drill before I left the house. Yeah, I appreciate you. Yeah.
Yep. Sold a lot of it. Yeah, let me see if oh, hey, no, he's oh, okay. Yeah, that's fine.
Yeah, I saw the therapy stuff. It went on for
Hey there.
where it's just like
Oh yeah. Thank you. Ladies and gentlemen, let's start finding our seats, please. Okay, we're going to reconvene the meeting. Our next affected party, I believe, is the county. Is that correct?
Yes, Mr. Chair. Steve Hofstadter is leading the team for the county.
Great. Good evening, Mr. Chair, board members. I'm Steve Hofstadter, the Director of Alachua County's Environmental Protection Department. And I want to thank you for the break. I desperately needed a drink of water, so thank you
Good
for that.
evening. Thank you.
Yes.
And the chair will recognize you as an affected party.
Okay. So I will not read a paragraph on that point. Again, I'm Steve Hofstadter. I've worked for Alachua County for 22 years. I've been in local government for 30 years. I'm a native Floridian. Before becoming the director of the department 6 years ago, I spent 13 years directly analyzing development impacts in Alachua County. With me, I have Mary Zoka. She's our water quality engineer. She has experience with stormwater design in this basin, and she'll probably hit on that a little bit as well. She's going to lead off the presentation when we start. Jeff Hayes, Growth Management Director for Alachua County, is here as well, and he'll conclude at the end. Also with us is Sylvia Torres, the Alachua County Attorney. For the record, in addition to presenting what we're going to present in the presentation today, we've provided a copy of that presentation. We also have resumes of staff who are going to be speaking to the item. We also have Stacy Greco's resume. She was going to be starting off her presentation, but is ill this evening and can't make it. She has over 20 years of experience analyzing water quality concerns in Alachua County. We also have a copy of the County Commission Chair letter that was given to the city on November 13th, 2025, that outlines our concerns in great detail, as well as demonstrates why we're a substantially affected party. We've also provided information from Dr. Kine Tran. He's an expert and UF professor in engineering, and his expertise is in subsurface investigation. He wanted to be here, but because of the change of meeting date, he is at a conference in Washington. So we've provided his information. He basically he has it. We've included his resume, some examples of the type of investigative work he's been involved with, as well as a statement in support of a need for more additional subsurface imaging and investigation for the Terra April projects. So that information is also in your backup information. Let's see, I think we'll take about 15 minutes. It shouldn't be long. Our presentation is not too long. But at this point, I would like to request the opportunity for rebuttal. It's usually requested at this time, if that is appropriate at a later date. And at this point, I'll turn it over to Mary to start off the presentation.
While they're getting that pulled up, good evening. My name is Mary Zoka. I am a professional water resources engineer in Alachua County's Environmental Protection Department. I have expertise in stormwater design and water quality. I have been sworn in and my resume is on file. So Alachua County recommends denial of a special exception permit to allow the placement of stormwater management facilities in the agricultural zoning district, as the applicant has not met its burden to show that this proposed use is appropriate in this location. This area is a very unique area. It has the highest concentration of freshwater springs in the world. Millions of dollars is brought to the region and local communities every year just from recreation alone. And so the protection of the water quality of these resources is imperative to the sustainability of the economy of our communities. The nearby Mill Creek Sink Cave is also a globally renowned resource. It attracts cave divers from all over the world. And West Skiles Water's journey shows us how we at the surface are connected to these cave systems. As you guys have heard already this evening, in 2005, a dye trace study was implemented where dye was placed at Mill Creek Sink, and within 12 days, that was detected at Hornsby Spring. For context, this is an extremely rapid travel time. Other areas of the Santa Fe Spring Shed have up to thousands of years of travel time. So for that comparison, 12 days is very fast. Dye was also detected at the Santa Fe Hills well. So this proves the connection to drinking water sources for communities that are down gradient from this area. This is a photo on the right of the dye going into the sink. Stacy Greco, who could not be here this evening, took that photo. And then the figure on the left shows the approximate location of where the dye was placed and where it was then later detected. And we all know that, sinkholes and sensitive karst areas are a common consideration for land development within Alachua County. But I want to go into a little bit of detail of why this site in particular warrants additional investigation. So as we've also heard earlier this evening, this site lies within the Cross County Fracture Zone. This site is adjacent to the Mill Creek Sink, which I have called out in this figure. This is an extensively fractured zone within the geologic layers. Water likes to take the path of least resistance, and so having these cracks and gaps in these sublayers has allowed water to flow more readily for thousands to millions of years. And so because of this, that has caused the dissolution of the carbonate in this area, which has left significant and numerous voids. In addition to this cross-county fracture zone, we are also right on the edge of the Cody Scarp. This is the erosional edge of the Hawthorne Formation. So coming from the northeast, that's going to be overlaid with clay soils. This is why we see creeks and surface water bodies in this area. And then as you leave this transition, it goes into the highly permeable sands on top of the limestone. So every river except the Suwannee River in the state of Florida goes underground when it crosses this Cody Scarp. So that in conjunction with being within the cross-county fracture zone is contributing to why we have such fast travel times, why it's so highly connected to the Santa Fe River and the other drinking water sources, and why it contributes so much to the water chemistry in this hydrologic system. So nearby the Terra sites, we've also heard tonight about the Mill Creek Sink Water Quality Improvement Project. That was constructed on the City of Alachua parcel that you can see outlined in navy blue. This figure shows this parcel with respect to the proposed Terra projects as well as the mapped cave system. So the intention of the Mill Creek Sink Water Quality Improvement Project was to treat stormwater before entering the Mill Creek Sink system for the protection of the water quality in this area. I was an engineer on the design of this project and performed construction oversight for this project. The engineer of record on this project, as well as the geotechnical engineer, gathering all of this information that I presented to you so far, found that it was necessary to implement geophysical studies before moving forward with the construction of this project. So they implemented ERI studies. This is a figure from the full geophysical report that was done leading up to the design of that project. And what was found by the results of these studies were two large anomalies that were likely significant fractures in the subsurface. This figure here is from Sam Upchurch and depicts this Cody Scarp retreat and why, after the overland flow passes these layers that are actively eroding, eventually infiltrate into this limestone layer and cause these preferential flow paths and fractures. So as a result of these studies, the entirety of the project was shifted north in order to mitigate potential sinkhole formation and protect the existing properties on site. And even with all of these extra measures taken place, a chimney solution sinkhole did express itself on site during construction in 2021. So this figure here shows, and one of these is a laser pointer. There we go. You can see many of the geologic features in the area. This is the Terra April infrastructure plan that we've seen tonight, and this is Terra Phoenicia. I'm showing both of these because Terra April is proposing will hold the floodplain compensation that is needed for the construction of Terra Phoenicia. So we cannot talk about one project without the other. And this is, proposed Terra Phoenicia with respect to that mapped cave system. You can see the other geologic features that have been expressed in the area. There are stormwater ponds right down the road that both have had sinkhole formations or sinkholes formed since their construction. You can see the results of the geophysical study anomalies here, and then these are active sinkholes on the Terra Forest West property. In addition to these, we've also heard tonight that there has been a quote from the ERP for this area saying how there will be no adverse impacts to surface water and wetlands. However, it does not discuss groundwater quality. So I just want to call out that shortcoming from that quote for the ERP. Second, we've also heard that this project is going to improve water quality. It's going to treat runoff from I-75. I have an email from FDOT. In my experience, it's really difficult to get FDOT to agree to let you collect their stormwater. So I reached out to FDOT about this. After I read this, I'll submit this to the record. This email has been shared with city staff as well as the applicant. The department prefers that the stormwater from the I-75 basin continue to free flow in the way that it does today without any restrictions. The department is in no need of water quality treatment since the I-75 basin has its own stormwater treatment system that was permitted by Suwannee River Water Management District. Additionally, the proposed plan will be cutting off base flow to the wetlands to the east. In an earlier email, when I was trying to orient them to the project, he said it still does not make sense on how they are getting water quality credits for treating the stormwater that is already treated. So based on the information I've shown today, it is unknown whether the stormwater utility is an appropriate use for the site. So we recommend this denial of the special exception permit to allow the placement of the stormwater management facilities. Alteration of site hydrology is what poses and increases significant risk of sinkhole formation. The recommended studies should be completed before the approval of the land use changes. Thank you. I'll pass it back to Steve Hofstetter.
Okay, sorry about that. Yeah, so kind of what I'm going to transition now is looking at the city's code policies and comprehensive plan policies that I believe support that this application not be recommended for approval at this time based on concerns with the protection of existing and proposed infrastructure and for the safety of our existing and future residents, our water resources, and county assets. We believe the application should be denied based on the following city comprehensive plan policies and land development regulations.
Sorry. Excuse me, Mr. Hofstetter. Sorry. Yes, sir. Just because I know Mr. Hofstetter appears to be going into compliance with conditions, and I'm assuming he's doing so on the basis of the materials he's attempted to move into the record. And I'm sorry I wasn't paying attention, but I understand that a report from Mr. Tran, I believe, was submitted with regard to geologic data, but that he's not here. Is that correct? So I would object to that going into the record because everybody here needs to be able to cross-examine him on that report. Otherwise, thank you. And therefore, any representations with regard to consistency based on that report.
Mr. Chair, I'm not going to reference his report at all. This is all based on our analysis. His report was, he asked that the city receive this information because he couldn't be here. We were willing to provide that information to you. So none of the presentation we're giving has anything to do with at least in terms of policy issues to Dr. Tran's information. He is just recommending, well, he has his own recommendations for additional analysis.
So, Mr. Chair, you can decide, or the board can decide to let the information in and give it the weight it deserves is one way to handle it. Generally, we recommend you receive all information from all parties in the public, and then you sort through it and determine what is credible and not. But you do have an objection. You should probably have some discussion about that objection and rule on it either now or later. So,
Members, what are your thoughts?
Well, I believe the evidence should still be submitted for review, regardless of whether or not the author is here to cross-examine. That's my opinion.
So, as I understand it, this information has already been submitted, correct? It's in the public record. So, to me, professionally, I would say it's there. Obviously, you can't do a Q&A on it or a rebuttal or whatever. Is this gentleman under contract with the county?
Mr. Chair, no.
Okay. To me, I think that's pertinent. This is just information, and that's the way I would view it. That's my opinion. Thank you.
Okay, do we need a motion on that, or
probably,
Okay.
for a clear
Members, can I
record.
have a motion on the objection, please?
Mr. Chair, if I might, I think the distinction falls on whether or not it would be considered expert testimony because he's not here to be cross-examined. It could certainly be brought in as public record like any other public record like emails that are sent in either in favor or opposing a project. And so that's the distinction is it could not be, I don't believe it, and the city attorney confirm or deny this, but I don't believe it could be considered expert testimony because he's not here to be cross-examined.
I would agree. But it is information you can accept and, like I said, give it the weight that you feel it's due.
So a motion on the evidence being accepted into the record.
Second.
And one of you has to make the motion. I can't make a motion.
Oh, I thought you were making a motion.
He said he needs one.
Oh, okay, sorry. So I move that we allow the information presented by Tran via the county's information to be submitted into the record with the understanding that it is not expert testimony.
No second.
It's been moved and seconded. All in favor, say aye.
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 Is there public discussion on that motion? Yes, please.
Thank you for the time, Rudy Rothsiden. It's going to be a long evening. We're all very aware of that. First off, I would like to, the attorney that has been brought here, if she's not paying attention to the things and everyone else is, that makes things very skeptical of what she is putting her mind to. But
Can
the
we
reason,
keep the comments to the motion, please?
yeah, the motion that we're talking about stems from the meeting that we had in December when it was moved, when the gentleman came up here and spoke and said, I have conflicting engagements on this date. I ask that you do this on a different date so I can have my testimony heard and rebutted and put forward. So that is what I wanted to communicate. Thank you.
Thank you. Any other comments? All right, let's proceed, please.
All right, thank you. Going back to where I was, at this point, it is the applicant's burden to demonstrate that they have met the requirements for the special exception. Under the city's policies 242, parent D, and should only be approved upon a finding that the applicant demonstrates that all of the standards in 24D are met. We'd like to highlight that under 24D4, the project must minimize environmental impacts and not cause significant deterioration of water resources, wildlife habitat, stormwater management, scenic resources, and other natural resources. So I don't think at this point, no one's challenging whether Mill Creek Sink in the cave system is significant as a significant geologic resource. And under objective 1.7 of the conservation open space element of the city's comprehensive plan, the city shall protect and conserve significant geologic features and their natural functions. And under policy 17E, the city can use regulatory techniques to ensure that stormwater, wastewater, and landscaping practices do not negatively impact the structural integrity, hydrology, biodiversity, and any other natural functions of significant geologic resources. Under objective, it is. Seems like, it doesn't seem like our entire presentation. Okay, let's see here. I apologize for that. Yep, we were in the wrong spot. There we go. Okay, under objective 112, of the conservation open space element, the city shall protect and conserve the water quality and quantity of water resources, not only for the benefit of the residents of the city, but for all of North Florida who depend on the Floridan aquifer for our drinking water and for the benefit of all connecting springs, streams, and rivers, which may be impacted by the city's land use and development practices. And under Policy 112A, the city shall recognize the interconnectivity of surface and groundwater systems and shall work to minimize degradation of the water resources which extend beyond the city limits. Per the city code, the applicant is responsible for demonstrating the burden to show that the applicant complies with the land development regulations, and the city and the parties do not have the burden to show that standards are met. The applicant must show that the use of the parcel is suitable and appropriate and does not deteriorate water quality and impact significant geologic resources. We don't believe they've done that. Therefore, Alachua County recommends denial of the application because the applicant has not provided competent substantial evidence to meet its burden for the requirement of Section 244 of the code, and that the proposed use is not appropriate for the site, is not designed to minimize environmental impacts, is not protective of geologic features as required by the Conservation Open Space Element Policy 17E, and water resources required under Conservation and Open Space Element Objective 112, and has the potential to injure neighboring land and property values. In conclusion, before I have Jeff come up here and make a few more statements, even though the city staff and the county are presenting kind of a different recommendation, we do agree on one critical issue. We both believe that the applicant should be providing additional site-specific geological study and field data prior to any construction and alteration of the property and other associated terra projects. We differ on when that recommendation should occur. City staff have stated that the use is appropriate, but the infrastructure plan should not be approved prior to additional analysis. So staff believes that the use is not appropriate for the site until the study has been completed and the results are analyzed and evaluated, and that in any other reason why we are recommending this application for denial at this time is based on the fact that we believe this analysis should be done up front, not before an approval of the special exception. Jeff, if you want to add a few more words.
Mr. Chair, Jeff Hayes. I'm an AICP certified planner with Alachua County. I'm the growth management director. Been with the county for 20 years. And I'll keep it very brief, and I don't want to repeat statements that have been made by other parties or the applicant or city staff. But I do just want to pick up on Steve's last point. There does seem like there's broad agreement that there is additional geophysical analysis that's necessary on this site. The city's expert testified to that effect. City staff have proposed conditions, and the applicant themselves have acceded to those conditions and have handed out a list of conditions to that effect. So it really is a matter of timing. I would point out, though, that at this step in the process, at the special exception step, it is critical, and Steve pointed to the policies in the city's comprehensive plan and the land development code that really speak directly to that the special exception shall be approved only upon a finding of the applicant demonstrates all of the requirements. We don't feel that they have done that as of this evening. One thing I want to point out is in a case such as this, from a planning perspective, at each step in this process, whether it be a land use amendment, a zoning or a special exception, or then moving on to site plan or infrastructure plan, the city narrows the scope of its purview, its discretion, and the extent to which it can condition any approval or justify a denial. And that's why it's really important to have all of the data. And I don't think it's an accident that the city's code and comp plan speak to having the data and speaking to demonstration of minimizing environmental impact at this stage in the process. I think that is the point, and that is why the language is so specific. One thing that's really critical is to understand that with approval of the use, I know there's been a discussion about whether you're just approving the use or you're approving the design of the stormwater facilities. And clearly, we're not at the stage of the design of the stormwater facilities. That would happen in the future. But you are prescribing that this use is allowed on all portions of of this property that are subject to the special exception, consistent with the conceptual plan. And why that's important is because that affects how much stormwater, both quantity and quality, because the stormwater, the reason the special exception is required is the stormwater would be coming from a commercial use. So the quality may be reduced from what it would be in a less intense use. And I believe that is why the city has the requirement for the special exception process to be demonstrated. And certainly additional quantity of stormwater is coming from a developed adjacent site, a commercial site, than it would be if it was an agricultural site under less dense and intense conditions. As Steve said, in much the way that the previous items on your agenda, you found that there was competent substantial evidence to recommend approval. We don't feel that there has been competent substantial evidence significantly submitted by the applicant to justify the approval this evening. The only other point is it's really important too. I think there was, Ms. Boyes had mentioned, and I don't think we've seen it yet, but the idea that the effective date of an approval, if it were to be approved tonight, may be pushed out into the future. I would say that it is this board who has been charged with approving and denying these applications based on the data presented. And it's not appropriate for, in the eyes of the county, for that to be pushed off to an administrative decision by staff. The use is important, and that's the use that you're considering tonight. And until you have that data, the county feels that the use should not be approved. Thank you.
Thank you. Is there anything else from the county? Members, do you have any questions?
I just wanted some, Chair, I wanted some clarification on, you were talking about at the beginning, the city's, the water treatment area that you worked with the city on, just some clarification on how you chose the location for that, when you did the research that you went through in that process, and then kind of what the connection was between the city and the county on that project.
So I worked in that capacity as with the private consultant that did the project for the city. So it was Wood at the time, now WSP. So from my knowledge, that site had already been designated for that project. That parcel was acquired using Water Management District funds to implement that specific project at that location.
I guess I have some additional questions for you. The email that you read into the record speaking about DOT, what is the date of that?
Yes, that was November 17th. And that same email was shared with staff and the applicant on that date, November 17th, 2025.
Okay, so the communication with DOT with their comments has been in the public record between the applicant and the city since November 17th?
Yes.
Do you know that it was received within a day or so, or immediate? In other words, what I'm getting at, has there been any dialogue between the city or the applicant with regards to the DOT comments?
Not to my knowledge with Alachua County.
Oh, and do you know how deep the basins are that were part of that Water Management District project?
Yes, the wet basin holds water at about 1.5 feet, and the dry basins vary in depth. I don't know exactly, but I want to say around 4 feet deep max on the dry retention basins that feed into the wet pond.
Okay, and this may be a city question, but within regards to the idea for the project, what was the genesis for that idea? Did that come from the city? I think it was a special appropriation or something, but what was the genesis for the idea to place that project at that location?
I am unaware of that history.
Okay. All right. Thank you.
Thank you. Our next affected party is, I'm sorry.
I don't have a question. I actually have just want to share a little info since the county has just presented something and I didn't see it in the materials in November, and the packet was like almost pages for today. But the chair of the commission sent a letter to the mayor. Are you all aware of that letter? Did you all get that? So you've seen that. So there are a couple parts. I'm not able to vote on this here, but there are a couple parts to the letter that I would like to read into the record, and for the benefit of the others in the audience, if they haven't seen that, if that's okay.
Please do.
The letter is dated November 10th. It was when we last convened on this item before the delay, and it's referencing the TAR April special exception. Dear Mayor Welch, the Alachua County Board of County Commissioners appreciates the City of Alachua's continued dedication to sound planning and protection of the community's shared water resources. In furtherance of these shared goals, the county has serious concerns regarding stormwater management of the proposed TAR Forest April, TAR Forest West, and TAR Benicia projects, and requests affected party status, which we've heard. One part in here that I think is really I was going to bring up earlier, so I'm going to, for brevity, not read the whole letter. Alachua County strongly encourages the City of Alachua to require the applicant to perform further geophysical investigation via electrical resistivity imaging (ERI) surveys prior to commencement of construction activities and prior to the approval of the site design expansion, as recommended by Wood Site Assessment Report and Geotechnical Engineer. Because of the Map Mill Cave System, a significant geological feature as defined by the city's comprehensive plan, and the known nature of active karst formation in the area, it is irresponsible to perform a significant land development and earth-moving activities without thorough subsurface exploration. While sinkhole formation is a common consideration for land development within Alachua County, these known characteristics for this area warrant this additional data gathering to best protect public health and safety, and requesting this analysis investigation is consistent with Objective 1.7 geological resources of conservation and open space element of the city's comprehensive plan, which states the city shall identify, protect, and conserve significant geological resources in their natural functions. And that was sent, but this is an excerpt from the letter from the chair. I just really wanted to add that as a summation of what was shared by county staff and some of the other experts, and may be possible for some of the citizens that may not stay to the end of that, which I might not stay as well.
Thank you.
Thank you.
Our next affected party, please.
We have one more proposed affected party, and then while she's coming to the podium, just to let everybody know where we are in the evening, following her presentation, then city staff will present the staff report recommendations and outline the conditions. We're going to have to open it after his presentation for, excuse me, additional questions from the board, but more importantly, cross-examination, because all the affected parties will be officially recognized. And so we will start with, excuse me, so sorry. We will start with the applicants, cross-exam of any of the experts they've heard this evening. We'll proceed to the affected parties, the Speleological Society, followed by the county, followed by the current proposed. And after that, do we do rebuttal at that point or public comment? It would be rebuttal.
Public comment. Those in opposition to the application.
Rebuttal's at the very end.
And then rebuttal.
Okay, so then there'd be rebuttal.
The city of High Springs is also here as an affected party, and we sent a letter as such. So I just wanted to.
You want to go before me?
I just want to make sure that they recognize.
Yeah, they'll.
Sorry to speak out of turn.
If there's testimony to present as an affected party, certainly you'll be right after this individual.
I'd just like to have it on record.
Right. Okay, there were no materials submitted, I'm told by staff, with the letter, just the request to be an affected party. So, okay, that's fine. Just so I
understand. As
understand.
long as we can public record make it known that we assert that we're an affected party.
All right, well, we'll hear from you right after this individual. Subject to any objections, I think Ms. Gadelia has.
Sorry for speaking out of turn.
Oh, no worries, no worries.
Ms. Lindberg, I saw your presentation materials, and I noted on the front page that you referenced that you were an affected party, and clearly that is the understanding of the city. There was no representation in those materials and nothing that was submitted otherwise to indicate interest. I'm sorry, I wasn't reading your notes. But so I just want to raise an objection to you being granted affected party status. Understand that clearly what would happen is that you'd have to indicate how you meet that standard. Otherwise, of course, the 5 minutes as standard for the public would be appropriate. Thank you.
Thank you. It's not my first rodeo, though. Mr. Chair, can I speak? My name is Soorya Lindberg, Soorya, and I am asking for affected party status because I am a resident of Santa Fe Hills neighborhood. I have invested hundreds of thousands of dollars into my house, and my neighborhood is served by a community well that is operated by the county. And as you saw in the dye trace study in 2005, and I'll show a map of that as well, the dye ended up in my well. So what goes into Mill Creek sink comes out of my kitchen sink. I shower in it. I drink it. My dog drinks it. So that's why I think I'm an affected party.
Members, how do you feel about this? Do you have any questions?
I have my water bill and my ID.
I think in the interest of this proceeding, we should recognize you as an affected party. So please proceed.
Thank you, Mr. Chair. So I am a member of a public, and I'm here to present to you some issues with the Terra April special exception permit and thus reasons for denial. Sorry, Mr. Chair, there was some conversation to my right. Approving this application with the condition that studies be completed later puts the decision before the facts. The board and the public should see the results of these studies before you vote, not after. Promises of future information are not a substitute for informed decision making. Mr. Chair, you make the rules along with the board, and you can decline their new conditions. You can say, I have heard so much that I say no, come back. The representative from APEC says public health and environmental integrity is a concern here. And Mr. Boyce, an expert, said investigate before design. I also want to note that your agenda documents had 696 pages of public comment. As someone who loves to read everything the city puts up, I couldn't even get through it all. And I think that this just goes to show that how serious the public views this. And thank you for taking this consideration so heavily. So next, oh, that's the pointer. Mr. Chair, is this the right remote for this?
I believe so.
Okay.
There you go.
All right. So this is the dye trace study we love to hear about. This was done in 2005. Everything I'm presenting to you is public record. And like I said, I'm an affected party because my home is on the path of the dye trace study the county presented. And not only am I in the path, my neighborhood serves 87 homes, was confirmed as a testing point for the study, as you agreed. And if you actually use a GIS map, and you draw a narrow oval north of 441 here, you get 1,500 residences. So this is not just about some land on April Boulevard. This is a community issue. This is a regional issue, and it's beyond 58 acres. This goes for 6 miles. I have that Excel sheet of the addresses too. Okay. The laser pointer doesn't skip it. There we go. Okay. So, Mr. Chair and board members, as you're approaching this decision strictly by the book, there is no requirement in the code or law that this application must be approved. This is called a special exception for a reason. It's an exception, not an entitlement. And the board's role is to decide whether to use this appropriate and not to assume approval. And here, Mr. Chair, I'm referencing a letter from attorney David Theriak, which is in the backup documents for this agenda. Mr. Theriak is an attorney, member of the Florida Bar, and officer of the court, and he also was the City of Alachua's land use attorney for over 20 years. And this is why I bring up this point. It says, moreover, as a matter of law, your client cannot have a vested right which compels the city to approve a pending application for a special exception permit for Terra April. So if there was any nagging, like, oh man, but they got this other land, like, here it is. So next, it is documented that city staff encouraged the applicant to submit Terra April with their neighboring properties referred to as Terra Phoenicia and Terra Forest West. And this came up at least twice. So you can see the map, Phoenicia's south, Forest West is big, April to the west, as we've seen through the night. Here it is in June 2022 in a letter addressing all three properties, Terra Forest West, Terra April, and Terra Phoenicia. The city manager says that even though they were submitted at different times, they're, quote, inextricably intertwined. Public records go on to show they had a meeting about it with the applicant who basically didn't take their advice, which is my interpretation. And this was confirmed in another letter to the applicant 3 months later in September 2022. So, Mr. Chair, why are these properties being presented separately? Why are they doing it this way in pieces instead of the whole as it was recommended by staff? I have an idea why. This is from another public record. This document from city planners noted here, and just like we saw in the previous slides from staff, in 2022 said Terra Phoenicia, parentheses, floodplain compensation, is dependent upon Terra April. Terra Forest West, parentheses, access to US 441 is dependent upon Terra Phoenicia. So let me switch hands. Let's go over that again, because I thought this really put it together, and I'm glad someone else did it to explain. Here's Phoenicia. Here's 441. We want to put commercial here, because of course, it's on the road. Oh, pointer broke. Oh, there it is. So this needs floodplain compensation from April, which is why we're here tonight. But guess what? Terra Forest West, it needs a road. But you can't get a road until this is here. And this is my interpretation of this quote. So staff said it's interdependent, multiple levels of staff. Also, anyone in my reading that has defended Mill Creek Sink and has brought up these questions, they all quit or got fired. So this is such a big deal to our city. All right. And something a little confusing, the first neighborhood meeting in 2021, they were all together. So it started that way. And then something changed. So it's confusing to me as a member of the public. I think it's a bit misleading. And it started off and it got split up. Okay. Oops. So throughout their presentation, the applicant will say the minor utility for a proposed stormwater project will treat runoff from I-75, which is a Florida Department of Transportation road. You heard it read into the record. Here's a screenshot of one of those. Turns out FDOT does not see it this way. Douglas Dykes, District Environmental Permit Engineer, on November 17th, 2025, said the department prefers that the stormwater from the I-75 basin continue to free flow in the way that it does today without any restrictions. Okay. Then it says the department is in no need of water quality treatment since the I-75 basin has its own stormwater treatment system that was permitted by the Suwannee River Water Management District. FDOT goes on to say, additionally, the proposed plan will be cutting off base flow to the wetlands to the east. Mr. Chair, as we heard, the burden of proof is on the applicant. Where are the documents to show that this benefits I-75? They are saying it. I don't see it yet, at least. So we also heard we're going to help clean the water that goes from I-75 to Mill Creek Sink. Well, guess what? My water comes from Mill Creek Sink and it's clean. I had a water test done by the county over Christmas. My water quality is great. You know what's going to mess up my water quality? Commercial development. In the past, they talked about hotels, asphalt, anything that comes from there. So, and I bring up commercial because this application is for 58 acres, but we keep talking about the little basins in the corner. So it's all connected. The water is not dirty. I drink it. I'm healthy, knock on wood. So does FDOT really need this? The applicant wants this. FDOT and the public, we have other ideas, it sounds like. So, but they need this for their other properties. All right. Here is another excerpt from Attorney Theriak's letter. It says, your client has failed to demonstrate compliance with Policy 5.1 of the future land use element of the city's comprehensive plan. It goes on to say, the Terra April project also proposes a substantial change in the topography of the subject property. And it says, Terra April project proposes to substantially alter, not protect, the natural topography of the city. And as I read this as a member of the public who loves Alachua, you've heard me say it many times, I'm not leaving. I'm going to live here for another 50 years. Compromising this rule with the topography, especially when I hear everyone else say how sensitive this area is. So, Mr. Chair, I'm curious, we don't know how much fill is proposed to fill or dredge this project. It's heavy, water's heavy, and that just, not even considering the FDOT argument. So it's a significant detail when it comes to weight, considering how sensitive we're learning this land is. Need some energizers. There we go. Okay. Here we see another record of city staff informing the applicant of what is needed. And this time, I found a public record asking for floodway encroachment analysis. Where is it? This came up in November 2022. It also says it requires hydrologic and hydraulic analysis to be continued to demonstrate that the cumulative effect of the proposed development when combined with other flood areas will not increase flood elevation. Cumulative. To me, I'm interpreting it as the other properties. So it's another reason to say, that's great, you want to do all this stuff, come back and put it all together. If they have conditions, those are mine. So, Mr. Chair, where's the report of floodway encroachment analysis? The burden of proof is on the applicant, and I would like to know. So here's the map again where I added an arrow just to show where it is. And I hear a lot about, when we hear about the conditions and the testing, I'm just really concerned, and this is not rehearsed or written down, it's coming from the heart, the promise to do the testing, and then it just disappears from us. The public doesn't get a view. We don't know what's going to happen. It's going to be behind closed doors. Bring it into the light. We can come back again. You name the time and day, we'll be here. You do not have to approve it with conditions. You don't need to. You can say no. It's an idea at best. You're in charge here. You could have a room of 100 lawyers and you're still the boss. You guys get to vote. And my other concern is with this is private land. Maybe the applicant could consider letting a third party come in and do some testing akin to Apex. Personally, I have zero interaction with the applicant, but I don't trust this process, seeing how staff has asked for things and it's not considered. So that could be interesting too. Here's the map. So, Mr. Chair, in pursuant to Code 23D5, affected parties presentation, I have a witness I'd like to introduce. Their land use planner named Michael Hill. I will bring him up to complete this presentation and we'll submit their resume to the clerk.
Let me get ready. Okay. Good afternoon, Mr. Chair, member of the board. Members of the board, thank you so much. My name is Michael Hill. I am a land use planner. I've worked predominantly in South Florida. I've got about 3 years under my belt, and I have a very proficient understanding of Florida histories and Florida's urban planning history. So if you want to sit and talk sometime, you can come find me. All right, so we're going to move on with this presentation. So the special exception criteria specifically deals with section 2.44, and it's because this is minor utilities by Article 10 in the definitions section of the Land Development Code, we're going to do it's 4.32 I4A. Excuse me, that is a mouthful. As noted beforehand, in section 2.44D, the special exception permit, okay, we have this 8 criteria that need to be met when it comes to a special exception. After doing an analysis of this application and the materials associated, what was highlighted and bolded here is what we're going to address that we believe has not been met with this application. So, here we have existing site conditions. As you see, we have the topography, and you can see that the highest point is about 80 feet above elevation, and then it depresses at every 5 feet going east, which is where the sink is and where the creek is. So, we can say that water will move that way historically. The city does not have a definition of compatibility within its Article 10 of the Land Development Code. However, as previously stated, the Florida statutes do in Chapter 163, which reads, compatibility means a condition in which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time as such that no use or condition is unduly negatively impacted both directly or indirectly by another use or condition. Therefore, if the applicant is going to say that he has to meet compatibility, then he must demonstrate that the allowed development of this project will not impact the adjacent properties, both directly and indirectly. And I have to say here, this is something that needs to be considered greatly when it comes to the analysis and the consideration of this quasi-judicial hearing. So, as you've heard from previous experts, we have the CARS. So, from the Florida Department of Environmental Protection, CARS is a generic term that refers to the characteristic of terrain produced by erosional processes. Sorry. Oh. Yeah. So, CARS is a generic term that refers to the characteristic terrains produced by erosional processes associated with chemical weathering and the dissolution of limestone or dolomite, the 2 most common carbonate rocks in Florida. Dissolution of carbonate rocks begins when they are exposed to acidic water. Now, the big thing when I looked that up was this. Florida Department of Environmental Protection said most rainwater is acidic. So that means that the collection of rainwater in these ponds could very well accelerate CARS activity in the area. As you see, we have a picture here from what it can create. Now, the site is within the sensitive karst area of Alachua County where the Floridian aquifer is and is near the land surface. As you see, here's some pictures that have been seen before. Now, let's talk with compatibility. So, the proposed stormwater facility is proposed near the area with known karst activity and formations. The stormwater detention and treatment facility in this location can lead to the accelerated formation of ground loss and sinkholes in the area due to the concentration of acidic rainwater. Therefore, application PSE 22-002 will have a negative effect on adjacent land uses both directly and indirectly and does not meet the definition of compatibility outlined in Florida Statute 163.31649. And therefore cannot meet the section 2.44D2 of compatibility in the city's land development code.
I'm sorry. The testimony has gone way beyond the concept of a professional planner into geology. So as long as we stay within the realm of what is proffered or offered, it's fine. But this definitely discussion of karst and I'm not sure what all this is, but the acidic, all of that is just beyond the scope of a planner.
That's karst. I would disagree that it is beyond the scope of a planner because I am not offering an opinion on karst. I am reiterating publicly obtained information that is on a public website for the Florida Department of Environmental Protection. Also, too, I have made my argument here about compatibility in the Florida statutes when it comes to land planning. Thank you. So as you see, the results of the assessment and analysis show the concentrations of hydrochemical components increase significant from rainfalls to the concentrated confluence in sinkholes. As you see, we have provided the sources for the Journal of Hydrology there. So, increased rainfall can cause the creation of sinkholes. Now, let's go to section 2.44D4 of the minimization of environmental impact. As you see, in general, commercial development would increase the impervious cover via the roads and therefore heighten erosion potential and more pollutants to water bodies, rely on drinking and recreation. Therefore, application PSE 22-002 does not meet section 2.44D4. Even Wood Engineering had concerns about ground loss in this area. Now, one question when I was reviewing the application was this. Most applications have what's called a SWIP, or a Stormwater Pollution Prevention Plan, okay? Generally speaking, there was not one provided with this application, and that is concerning considering this is a stormwater detention and retention area. Now, I'm not going to point the finger at anything, but it is concerning because how can the applicant say that they are minimizing environmental impact and minimizing pollution when they don't even have a pollution prevention plan? Now, let's talk about section 2.44D5 and section 2.44D6. Due to the proximity of the project being near the Interstate 75, if a sinkhole is to open up in this area, it not only could compromise the interstate, but it could also compromise April Boulevard, which is an FDOT right-of-way. So, though the intention of the code is traffic-related, it can still impact public right-of-way from a construction perspective.
Cross now over into structural engineering. I understand that this is not a typical courtroom proceeding, but with some limitation on the value of the statements and the interpretation with regard to environmental resources, karst features, geology, and now structural engineering, there has to be some kind of limitation and some parameters put around this testimony. It's just way beyond the pale. I don't think it's appropriate. And I think I need some kind of action from the board with regard to the continued nature of the testimony.
Are you asking, what specifically are you asking the board to do, Ms. Cordelia? Just so we can frame for you.
To have the expert witness either provide credentials to support the statements and the conclusions and that he's making, expert conclusions, or to stick to his testimony falling within the parameters of a professional planner, which I believe is what he indicated he's qualified to provide.
And Mr. Chair, you would need to decide. The board would need to decide.
Mr. Chair, can I make a point to that?
Members, what are your thoughts on this?
Mr. Chair, if you can just give us a moment, please, Mr. Hill.
Yes.
So as I'm listening to all this, I think just viewing the aerials and and certainly took a lot of thought and time into the information. But for me, it's kind of getting on a slippery slope, okay? I don't know your qualifications, sir. I suspect in this room there are multiple professional planners. And to me, it's kind of crossing the threshold of perhaps these are public comments, if you will. Miss Lindberg, I understood. I know she doesn't live in the city. She lives in Santa Fe Hills. I think we're all very familiar with, how Santa Fe Hill operates, if you will. But I think we're going down a slippery slope here. I think what I'm hearing is opinions, but I'm not hearing necessarily competent and substantial evidence. So that's just my thoughts. So I'll defer to the rest of the board. Thank you.
I tend to agree with you. I think this is going into more opinion, and I'm not discounting you at all. I'm sure you have quite an extensive career, but I want to stick to factual items. If you have code, that's fine, but the rainfall and whatnot is opinion.
Okay. So then my question to you is, is this. So then let's talk about ground loss. So we know that ground loss can occur in that area. And it has been noted by the city's expert that ground loss will occur in that area. So, but I'll keep moving. So, again, we believe these sections will not be met because of potential ground loss. So, now let's talk about the city's review of a site plan. Now, after reviewing the site plan, one thing that brought to my concern was this. I noticed on the civil sets, when I was looking through it, that the site plan was not signed and sealed by a licensed Florida design professional. And I have had stories from colleagues of mine in the planning world where they stamped civil plans that were not signed and sealed by a licensed design professional. The cities that they worked at got sued, and the courts ruled against the cities and said that, well, you stamped it, so you have to abide by it. You can't burden the landowner anymore. So and again, before I got into this meeting, I went back and double checked, and I did not see a signed and sealed signed and sealed from the licensed design professional in this site plan. So I believe this site plan is not a full and complete site plan and does not meet the definition of a site plan in the code. So if the city cannot proceed until a site plan proposing a specific development is submitted to the city for review. Therefore, the application does not meet 2.44D7, which is drawings. Now, one thing also too that is concerning on the special exception permit application, and again, this is not something crazy to torpedo the project, but it just again kind of echoes the inconsistencies that are with this application, is that the acreage is inconsistent, the future land use designations and everything are inconsistent, and so are the parcel ID numbers. So, but again, this isn't something that you can deny on and that, oh, it's breaking the law. But again, it's another inconsistency that needs to be brought to the board's attention. Now, let's go into utilities. As previously mentioned in my presentation, we talked about the state's definition of compatibility. In 4.32I4, it mentions compatibility again in B and also in II. If you look at those two sections, they are based entirely off of each other. So we have demonstrated that it will not meet compatibility, the state's definition of compatibility in 163. So therefore, it cannot meet the definition of compatibility in 4.32I4. And as you see, there they are. And therefore, we're making the thing. It does not meet the definition of compatibility in 4.2I34 for utilities minor. Now, in 6.93, it says that the purpose of this subsection establishes the design performance standards for stormwater management systems, and its purpose is to ensure stormwater management systems are established to minimize flooding, erosion, and sedimentation, and protect and enhance water resources. Board, you have heard competent testimony from other experts, both geologists and engineers, that this will have an adverse impact on water resources. So therefore, I say that this code section has not been met. And therefore, because of that, it's now in violation of 2.44D8. So in our final analysis, you can see the application does not meet 2.44D2. It does not meet 2.44D4. It does not meet 2.44D5. It does not meet 2.44D6, D7, or D8, or 6.93. There is too many inconsistencies that do not meet the code minimums for this application, and that could be problematic down the road. Thank you.
Thank you.
Thank you, Mr. Chair. I do want to make a point. You mentioned rainfall is not acidic. We got that from the Florida Department of Environmental Protection, so that was the source of the information.
Thank you, and I appreciate you putting this together. Our next affected party, I believe, is High Springs.
Hi, my name is Jennifer Appleby. I'm the City of High Springs Parks and Recreation Director, and tonight I'm serving as the acting city manager for High Springs. We'd like to assert that we are an affected party. The location, do I have that we are an affected party by just offering me to speak?
I would grant you, the chair grants you affected party status.
Okay, thank you. The proposed location of the basin has the potential to be significantly detrimental to the quality of our drinking water, and we have a sincere vested interest in this board's decisions and the consequences of this decision. We, the City of High Springs, are committed to preserving the quality of our water, our rivers, our wetlands, and the Florida aquifer. It has been stated several times tonight, High Springs has been mentioned in name. 12 days after a dye test was performed, those results were seen in Hornsby Springs, which is in the city limits. And it was mentioned to us by City Council that we needed to be present and publicly state that we are an affected party in addition to the letter that we sent to the city. And that is all I have, as I feel that the body of evidence that was presented by tonight by the Speleological Society, the county, and other affected parties speaks for itself. And it is our recommendation that you deny this exemption. Thank you.
Thank you.
So according to your code, we're now moving into public comment.
Very well.
Sorry, we forgot the staff report.
Oh.
Sorry. It's getting late. We need to bring the city staff back up to present the staff report and recommendation.
Okay.
And then we go off to public comment.
I don't know. I'm an affected party. I don't know that I got on a list or anything, but I'm with Camp Kulaqua at High Springs. I don't know if you have time or not.
I think High Springs is recognized as a affected party.
Mm-hmm.
And do you have any new information to offer?
No, I was just saying that we have a concern about the quality of the water that's going to come to Hornsby Springs. We have over 50,000 people a year that come there, children and families that come, and we're concerned about that, about changing the water quality that comes to the camp. And we are been there since 1953, and so we've enjoyed the beautiful spring that we've had there. And we're just concerned about any changes that may take place since the test showed up in Hornsby Springs the 12 days later. So that's our concerns. And so I just wanted to make sure we recorded those.
Thank you.
Okay.
Appreciate it.
Mr. Chair, who are you?
Yes, please state your name.
Yeah, I'm Phil Yantz. I'm the executive director of Camp Kulaqua. Yeah.
Thank you so much.
Do we have the gentleman's name for the record? He did. Okay.
Is there any others looking to claim affected party status?
Good day. My name's Sarah Younger. I live at 26805 Northwest 182nd Avenue in High Springs. I am on well water, and I, as well as many others in my community, are very concerned about what we receive as water from the basin. So I feel I'm an affected party on this, and I urge you to listen to those items. Thank you.
Okay, thank you.
Hello, for the record, my name is Soyini Kojo, and I live north of the proposed multiple Terra developments. I have well water, and I have stakeholdership and any decision made tonight, as well as my neighbors. Just want to thank everyone for coming out and hoping that the chair and the board can really take into consideration the long-term effects that this can have. Would love to build a community that will be here for a long time versus a short time. Thank you very much.
Thank you. Any others?
Yes, my name is Carl Savoy. I live in High Springs, directly in line with the maps you've already seen. and myself and my neighbors all have well water, and it's been perfect so far. And we're really concerned about this development coming in and the unknowns that could happen in the future to affect all of us and all our neighbors. Thank you.
Thank you.
Mr. Chair, we should move to the city staff report at this point.
Yes, let's proceed with the city staff report.
Thank you, Mr. Chair. I wish I could say this would be brief, but it will not. But it will be thorough.
Please proceed.
So, there were 2 neighborhood meetings held in this application process. The first was held on April 25th of 2022 by the applicant's agent, EDA. The mail out was sent to the registered persons and organizations who are on the city's registered mailing list, notification mailing list, and also a public notice was posted in the newspaper general circulation. A second hearing was then also held on May 11th, again at the Alachua Branch Library meeting room, and this one was mailed out to the property owners with 400 feet of the property of the proposed project. Materials submitted by the applicant indicates that both of the meetings were unattended by any residents or concerned citizens. The special exception permit compliance and LDR standards under review are subsection 2.4.4D, which states that a special exception permit shall only be approved upon a finding that the following standards are met. It complies with the use-specific regulations, compatibility, design minimizes adverse impacts, design minimizes environmental impact, roads and other public facilities, not injure neighboring land and property values, the site plan, and complies with all other relevant laws and ordinances. So, in relation to section 2.4.4D1, complies with use-specific regulations. It's required to comply with use-specific regulations. The proposed special exception complies with all relevant standards in section 4.3, use-specific standards, or section 5.2.3B as applicable. The evaluations of staff and findings are that section 2.3.2 I4 establishes use-specific standards for minor utilities. It must be located within reasonable proximity to the area to be served. The zoning designation of the location of the stormwater detention and retention facility allows minor utilities, and the stormwater detention and retention facility meets the compatibility requirements as set forth in subsection 4.3.2 I4B. And the stormwater detention and retention facility provides an enhanced natural, e.g. increased topographic relief, vegetative diversity, etc., or recreational, e.g. perimeter trail, boardwalk, interpretive kiosk, etc., functional use. Evaluation findings continued. The proposed stormwater management facilities are directly adjacent to the community commercial area to be served and is under common ownership. Per table 4.1-1, stormwater management facilities are allowed on land zoned agricultural. Surrounding uses are a minor utility in land zoned agricultural and conservation lands, and an interstate highway. Adequate screening and buffering is being provided as needed. The proposed special exception permit is conditioned upon provision of a perimeter trail system with interconnectivity to the community commercial Alachua Stormwater Improvement Project and residential developments to the east. Section 2.4.4D2, compatibility. The proposed special exception is appropriate for the location and compatible with the character of surrounding lands and uses permitted in the zone district. Evaluation of findings, section 4.3.2 I4B outlines compatibility as providing adequate setbacks, screening, and buffering around the perimeter of the proposed use if it is deemed necessary to ensure land use compatibility with surrounding uses. No screening or buffering are required as part of the special exception permit, but will be required as part of the subsequent infrastructure plan. Section 2.4.4D3, design minimizes adverse impact. The design of the proposed special exception minimizes adverse effects, including visual impacts of the proposed use on adjacent lands. Furthermore, the proposed special exception avoids significant adverse impact on surrounding lands regarding service delivery, parking and loading, odors, noise, glare, and vibration, and does not create a nuisance. Evaluation of findings, the proposed stormwater management facilities and perimeter trail system will not create adverse impacts to service delivery, parking and loading, odors, noise, glare, and vibration, does not create a nuisance. Section 2.4.4D4, design minimizes environmental impact. The proposed special exception minimizes environmental impacts and does not cause significant deterioration of light, water, and air resources, wildlife habitat, stormwater management, scenic resources, and other natural resources. Under evaluations and findings, the proposed special exception permit would allow for stormwater facilities to be constructed on previously forested land that's been harvested and cleared. The construction of the stormwater management facilities and a perimeter trail network will not cause the deterioration of light, water, or air resources, wildlife habitat, stormwater management, scenic resources, and other natural resources on the land surface. During the infrastructure plan process, the city will require site-specific subsurface field data appropriate to the hydrologic setting of the site. Section 2.4.4D5, roads and other public facilities. There is adequate public facility capacity available to serve the proposed special exception, and the proposed special exception use is designed to ensure safe ingress and egress onto the site and state road conditions around the site. Evaluation of findings, the proposed special exception permit will not have any impacts to public facilities, and temporary ingress, egress, and parking to the trail network will be provided on the community commercial zoned area. Section 2.4.4D6, not injure neighboring land or property values. The proposed special exception will not substantially injure the use of neighboring land for those uses that are permitted in the zone district or reduce land values. The proposed special exception permit will have no impact on neighboring uses or reduce land values. Section 2.4.4D7, drawings, a site plan, subsection 2.4.9 of the section, or preliminary plat, subsection 2.4.10 G3 of this section, has been prepared that demonstrates how the proposed special exception use complies with other standards of this subsection. Evaluation of findings, section 2.4.9 C5 exempts minor utilities from the requirements to provide a site plan. And the proposed special exception permit application includes a conceptual master plan which depicts the stormwater management facilities and the perimeter trail system. Section 2.4.4D8 complies with all other relevant laws and ordinances. The proposed special exception use complies with all other relevant city laws and ordinances, state and federal laws and regulations. Evaluation and findings, the application is found to comply with all other applicable city laws and ordinances, state and federal laws and regulations. The environmental condition analysis, basically all of the criteria under site suitability, wetlands, water bodies, strategic ecosystems, regulated plant and animal species, soils, flood, karst sensitivity, and wellhead protection were deemed satisfactory by staff analysis. Therefore, staff recommendation on the special exception permit Staff recommends that the Planning and Zoning Board approve the special exception permit submitted by Clay Swager, AICP, lead AP of EDA Consultants Incorporated on behalf of Terra Forest LLC, subject to the 11 conditions provided in Exhibit A and located on page 23 of the January 13th, 2026 staff report to the Planning and Zoning Board. So, staff's recommended conditions. The applicant acknowledges and agrees that the applicant shall install an interpretive kiosk on the City Water Improvement Project site, the Mill Creek Stormwater Enhancement Area, with the location of the kiosk to be determined by the City of Alachua. In its sole discretion, this condition shall be the obligation of any subsequent party with interest in the property subject to this development order. The applicant acknowledges and agrees that the following use shall be prohibited on the land zoned community commercial and located on tax parcel number 03020-000-000. Gasoline sales, general industrial service as a principal use, laundry and dry cleaning and carpet cleaning as principal use, tire sales and mounting as principal use, parking lot as principal use, park and ride facilities. In this condition shall be the obligation of any subsequent party with interest in the property subject to this development order. So essentially eliminating almost all the automotive or anything that's going to accumulate hazardous wastes on the site, hazardous potential waste on the site. Number 3, the applicant acknowledges and agrees that at least 2 points of access from the proposed trail network to the future commercial development area with trail signage will be provided with the exact location of the trail and the access points determined at the time of development plan review for the commercial area on tax parcel 03020-000-000. Points of access shall be approved by the city staff during the review of a development plan, e.g. the site plan or other applicable development review process. This condition shall be the obligation of any subsequent party with interest in the property subject to the development order. Number 4, the applicant acknowledges and agrees that future commercial development shall be required to provide internal pedestrian network, sidewalk connections to the adjacent trail network on tax parcel 03020-000-000. The internal pedestrian network shall be approved by city staff during the review of a development plan, e.g. site plan or other applicable development review process. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Condition 5, the applicant acknowledges and agrees that the construction of the trail network shown on the plans shall occur with the construction of the interconnected basin system and may be modified subject to the site-specific field data provided during the infrastructure plan review process, should the basin system be approved. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Number 6, the applicant acknowledges and agrees that the parking areas shall be temporary and shall remain in place until permanent parking is constructed as part of the future commercial development presently located on tax parcel number 03020-000-000. The temporary parking shall be on unpaved stabilized surface. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Number 7, the applicant acknowledges and agrees that the applicant and owner will obtain all other applicable to local, state, and federal permits before the commencement of site work. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Number 8, the applicant acknowledges and agrees that to ensure the continued compliance with the City of Alachua Comprehensive Plan and land development regulations, the development order authorizing this special exception permit shall be recorded in the public records of Alachua County, Florida, within 5 calendar days of the effective date and shall run with the land. This application further acknowledges and agrees that the applicant shall be responsible for all costs associated with recording development order in condition the public records of Alachua County, Florida. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. It was a long one. The applicant acknowledges and agrees that the development order for special exception PSE 22-0002 will not take effect until the work outlined in the Apex Companies LLC recommendations attached hereto as Exhibit A is completed. Number 10, the applicant acknowledges and agrees that the stormwater management facilities for Terra April will be re-engineered prior to the development order for special exception PSE 22-0002 taking effect, should the results of the geophysical evaluation and geologic testing necessitate it. And finally, number 11, the applicant acknowledges and agrees that conditions 1 through 10, as stated above, do not inordinately burden the land and are proportionate to the rationally connected to the impacts of the proposed development, and shall be binding upon the property owner, including any subsequent property owners, successors, or assigns, and that the special exception permit shall comply with conditions 1 through 11 as stated herein. And that concludes the staff report.
So, Mr. Chair, at this point, if there are questions the board has of staff, it would be appropriate to entertain those. And then we'll need to inquire if there is, if the applicant or any of the affected parties wish to cross-examine any of the experts who testified tonight.
Very well. Any members want to ask any questions of staff?
Mr. Chair, I got a question. It's been mentioned that this particular parcel of 58 acres is intertwined with the other two Terra projects. Can you speak to that? I read the letter that Theriac drafted and some of the stuff that the previous city manager wrote in response to correspondence. So could you speak to that?
Mr. Chair, I can speak to that, but understand that we're not evaluating the Terra April infrastructure plan, which is actually what is the interconnected portion. The application before you is for the special exception that would allow for 2 stormwater basins to be constructed as part of that infrastructure plan. But if that infrastructure plan, which will be heard in a future hearing, is not approved, then essentially the approval of the special exception becomes rather moot, because it will be approved as part of that infrastructure plan. All that the board is actually evaluating tonight is just whether or not to grant the special exception that would allow the applicant to build those basins in an adjacent parcel as part of a future infrastructure plan approval. And so there is substantial interconnectivity between Terra April infrastructure plan and Terra Phoenicia infrastructure plan and Terra Forest West. But again, I hesitate to get too far down that road because that's not what the application before you is actually addressing.
So the reason for my question is because I heard something and I also read about compensatory storage for floodplain impacts, and I feel like that's because of Terra Phoenicia, right? And so if we're looking at an approval for a special exception on Terra April that's connected to Terra Phoenicia, then I think that information is pertinent.
Mr. Chair, the stormwater that you're referring to is, again, it's part of the infrastructure plan. The 2 basins that are contemplated as part of the special exception that would be granted if the special exception is approved would not take any stormwater from any parcel other than the community commercial parcel that's adjacent to. The additional stormwater basins that are contemplated as part of the Terra April infrastructure plan would take that extra water, and that would potentially have an impact on Terra Phoenicia.
I understand. And I guess that explains the size of the retention pond, because we have 58 acres and we're talking about a 10-acre community commercial site.
Yes,
so 48 acres of stormwater pond?
As described in the earlier overview, only about 6 1/4 acres are being proposed for the 2 stormwater basins and perimeter trails that would take the water for the 10 1/2 acres out of the 58 plus total. Yes.
Thank you.
My question relates, so looking at number 9, and we've heard this question a lot tonight or condition number 9, in the testimony. Can you explain why the staff recommends doing the Apex study after, why we're doing it in the order that we're doing it, just for understanding?
Basically, staff's recommendation for that is because, let me get back to number 9. So basically what this does is it limits the ability of the developer to move forward at all on the stormwater basins for the special exception unless all of the studies have been completed and reviewed by the city's expert. The results of those will determine if any modifications need to be made to the April infrastructure plan, the larger stormwater basin plan, and also potentially to the 2 stormwater basins that would be approved by the special exception. I want to make it clear to you all that the approval of the special exception does not grant them the ability in any way to actually construct those basins. They have to have the approval of the infrastructure plan in a subsequent set of hearings or hearing before they could actually get approval to construct those basins.
And that's with that hearing is with the city commission? Yes. Okay. I think the only other thing I just wanted a little bit of clarification on, because it says, in number 10 that, that it would be re-engineered prior to the development order. So if the study determines that it is a risk or that it is, unwise to build there, does that condition give the city, the authority to say, no, you can't do it at all? Or how does that kind of work?
That would be then reviewed during infrastructure plan hearing by the city commission. The results of that study would then be a part of that hearing, and they would base their decision on whether or not to grant infrastructure plan on, among other things, the results of that evaluation.
Thank you.
So, Mr. Chair, so what I hear is, well, basically the application states that, stormwater and infrastructure plans will be submitted later, right? We've heard that. And so what I'm trying to wrap my head around is whether or not the board's being asked to rely on a future review to satisfy today's special exception findings. And so that's where I need some clarity.
So, Mr. Chair, I understand the confusion in that, but again, the special exception does not grant the ability to actually construct the stormwater basins. The study that's going to be conducted, at least should, provide guidance on how those basins would then be constructed, but only through the approval of the April infrastructure plan. And so, again, the approval of the special exception does not grant any rights for development without the April infrastructure plan also being approved. It basically just says that if that's approved, then they could construct them off-site on an adjacent parcel.
Okay, do we have any other questions from the?
Okay, right. So from the code under administrative, special exception uses may require the imposition of conditions to ensure the appropriateness of the use at a particular location. And so without that study to determine what the appropriate use is, the appropriate use may come back that it's an allowable use. It may come back that it's an inappropriate use. And then as part of the infrastructure plan hearing, that'll be the determination for that will be made at that based on the new evidence from the geophysical evaluations.
Okay, thank you. So I have a couple of questions. These may not be for you. If they're not, just let me know, and then we'll
Okay.
flip over when it's the applicant's turn. Whose idea was it to come up with this FDOD concept on this site? Do we know?
Mr. Chair,
Historically.
that was done significantly before my time, but um, as the applicant or the owner, at least whoever that was at the time when the comprehensive plan was amended, that was a requirement of the city. It was put into the comprehensive plan as a sub-element specific to that parcel that said that to develop the community commercial portion, they would in turn have to take that stormwater off of I-75, at least a portion of the stormwater off I-75, and treat it to a higher level. And so that was actually a requirement of the city at the time.
Okay, so I'm just going to wing it and say probably the city asked for it at some point because it ended up as a text amendment to the comp plan. And the actual master plan is part of the application, which is part of the evidence for the special exception, correct? The little master plan with all the trails and everything? Not the infrastructure plan,
Right.
the master plan, which is what it's being referred to.
In reference to that, yes, it's part of the evidence for that to demonstrate the intent of where those two basins would go in the conceptual site plan that was submitted.
Okay. And so basically, I guess, I'm not going to speak to the applicant thing, but basically what we're looking at, excuse me, is three basins here. One basin is supposed to be for the DOT concept with the stormwater from I-75. And then the other two basins are having to do with development on the community commercial site only, or are those, and this is why it's difficult for me, because basically the infrastructure plan won't come back to us. We don't know at this point in time, putting the geological stuff off to the side, we don't know if those two basins are oversized. And these are probably questions I will want to ask of the applicant at that particular time. In other words, is the applicant wanting to do off-site stormwater? Because special exception, in my mind, is simply a use question, right? But somehow we've got ahead of ourselves with all these other things, in my estimation. And so that causes me to ask some more additional questions. And of course, the whole idea about the trails and the kiosk and all that stuff, I'm guessing perhaps the city made that as a condition at the time, because this has been going on for a few years. But the questions about the sizing of the basin and the fact that the infrastructure plan won't come back to this board causes me some difficulty, because I'm basically approving a use without really knowing what the end answer is. I'm pleased to see that the city, and I just want to clarify because I heard somebody say about Apex working for somebody, or I don't know the applicant, but Apex is all under contract to the city, right? And you're representing our interests only. So I just want to clarify that because I heard somebody mention that at one point. So it's difficult for me with regards to that. And I say that to say this: is there anything in our code that would preclude, if the city were to move forward with a special exception, that could require the infrastructure plan to come back to this board? So we would have some semblance of, at the end of the process, what was envisioned and told to us for the use actually occurred. Is that even feasible or possible? I know what the code says, but I'm asking if that in essence could be a condition.
Mr. Chair, generally no. Conceivably, if an amendment to the special exception was necessary, then that would come back before you. But if the geologic evaluations come back and applicant decides to move forward with the infrastructure plan, then that would all be handled as part of that. But as part of the special exception approval, only water from the community commercial portion is allowed to go to the stormwater basins that are being proposed as part of the special exception approval. No oversizing is contemplated as part of that. I can't speak to the application for April infrastructure plan yet, because I haven't started evaluating that yet. But if there is any, I believe that's where it's likely to be.
in the two basins,
the big basin.
the big
No, ma'am,
basin.
as part of the infrastructure plan. The two basins are only allowed to take stormwater from the community commercial portion of the parcel.
All right, thank you.
Just for clarification, when you say the big basin, you're talking about the one with the I-75 runoff at
Correct. The one that's not actually part of the special exception, but will be part of the infrastructure plan.
Okay, thank you.
Any more questions?
Now we, Mr. Thomas, arrest, and we move to ask if any of the affected parties, well, we would start with the applicant, and then after the applicant, if any affected parties wish to cross-examine any of the experts who've testified tonight. Please let us know.
A little bit of rebuttal.
Well, rebuttal comes later.
Okay.
So we're at cross-examination now.
Cross-examination.
Of
No, I'm
anybody,
good with that.
any of the experts who testified tonight.
I think we're good. Thank you.
Okay. National Speleological Society, Ms. Graham, do you wish to cross-examine any of the experts or city staff tonight?
Not at this point.
All right, and then Alachua County? Alachua County? Okay. Ms. Lindberg, will you be doing any cross? All right, and then there were 2 or 3 other affected parties, High Springs. I'm sorry, I didn't catch all the names. Will any of the other affected parties be doing cross? If you are, raise your hand. You would? No? I'm sorry, ma'am, in the back. Okay, so it sounds like we've got Alachua County next and Ms. Lindberg for cross.
Yes, ma'am.
Is the county ready?
Good evening, Mr. Chair. My name is Sylvia Torres. I am the county attorney with Alachua County. I have been with the county since 2012, and I was involved in the last litigation over the Walmart properties. I have questions for, I'm sorry, I'm going to butcher your name. It's Alfredi with Apex. I don't know how this is done. Should he step up here?
No, he'll have to. It's the only microphone we have.
Okay. We can share.
And Sylvia, if you could make sure, both of you really make sure you grab hold of that microphone and talk into it.
Okay. Did you undersign the letter to Holtzman Vogel on December 23rd, the one that's in the record, that has 6 essential work tasks for geologic opinion?
Yes.
So in that letter, you wrote that these were essential work tasks required to perform a professional geologic opinion regarding the proposed stormwater management system. Do you stand by that?
Yes.
Could your work tasks have been completed prior to this hearing?
Yes.
Assuming full cooperation with the applicant, when is a reasonable timetable that you could get those work tasks completed?
Well, it'd be the applicant that'd be doing the work and then providing it to the city for my review.
How long would that take in your experience?
It depends on the number of geophysical anomalies, points tested within the photolinear intersections, as well as any other anomalies identified.
Could it be done in 3 months?
Potentially 3 to 6.
3 to 6 months, okay. Is this subsurface investigation essential to determine the overall stability of the site?
Yes.
So without this investigation, we don't know whether the site would be stable for this kind of a construction.
Yes, you need additional testing.
Okay.
So the city code, section 2.4.4D4 requires this board to find that the special exception minimizes environmental impacts and will not cause significant deterioration of water resources. Would the results of your study be useful to this board in determining whether it minimizes environmental impacts and will not cause significant deterioration to water resources?
Potentially, yes.
The city's comp plan, that's Coast Policy 1.7.E, requires this board to find that the special exception does not negatively impact the structural integrity, the hydrology, the biodiversity, and other natural functions of a significant geologic resource. Would the results of your study be useful to this board in determining that the special exceptions do not negatively impact, etc.?
Yes, potentially, yes.
Thank you. That's all I have. Okay, and Mr. Thomas? Mr. Thomas, how long have you worked for the city?
Since June of 2025.
So, Mr. Thomas, were you with the city when the county, well, we have established that you were not with the city in 2006 when the county challenged Swanee River Water Management District permit, a general permit for stormwater on an adjacent site.
That's correct.
Okay. And we've established that you were not with the city in 2015 when the county brought we brought a comp plan challenge and a cert challenge against the Walmart site on the southeast corner of the intersection of I-75 and 441 and the two adjacent properties.
Also correct.
Okay, the city has files on those. We received those when we did a public records request recently, and of course the county has those files as well that could be available subject to a public records request. Have you reviewed any of those files?
Only very superficially.
So, Mr. Thomas, you heard from Apex that to know that the site is stable for use as a stormwater facility, you need that additional testing. What do you consider the purpose of a special exception if it's not to determine that the site is appropriate for that use?
Were we contemplating an actual development permit? That would be one thing. But since this is just to allow for this, once the evaluation has been completed and incorporated into an infrastructure plan, I don't see the conflict in moving the special exception forward because it doesn't grant any rights for actual development.
So, Mr. Thomas, the rights for actual development might not come until a final development plan or until a final plat. Does that mean that you can approve a final development plan that's not consistent so long as you can't build until you record a final plat?
The development order, as listed in the conditions, the development order will not go into effect until the evaluation has been complete. Even so, the construction would not be allowed until the underlying infrastructure plan was permitted, was approved.
So there are many steps in the process of a development coming into fruition. There are steps that are done by the city. There are steps that are done by the Swanee River Management District. There are steps sometimes that are done by the county. What are you asking this board to do if it's not to determine that that site is appropriate for that use?
What I'm asking, or not I'm asking, but what we've evaluated is the applicant's request to approve a special exception that if the geotechnical evaluations demonstrate it's allowable or it's advisable, could go forward. Without that, and without the subsequent infrastructure plan that would be required to do the actual approval and construction of those stormwater basins as part of the special exception can't move forward anyway. The actual construction of the special exception basins can't move forward.
The way that your condition is written, the special exception is effective if it's determined by the Apex study that it's appropriate, that it's a site that can have this use.
The way it's written, the study would have to be completed, and then if the results of the study demonstrated it, then adjustments would have to be made. Conceivably, adjustments all the way to the point where it would be denied because there was too much of an issue that could be resolved, and so until that's done, there's not really any way to determine.
Who's going to look at that study and determine whether that means that it needs to come back to this board, for example? Who is going to make that determination that that study shows that that site is appropriate for that use? If not this board.
That would be incorporated into the application for the infrastructure plan, which goes before the city commission.
Mr. Thomas, what is an infrastructure plan?
The infrastructure plan lays out how they're going to develop the underlying infrastructure. In this case, it's stormwater basins. It would be the actual site plans for the actual development with the engineered stormwater basins.
So what you said was that the infrastructure plan lays out how you're going to develop it, not whether you're going to develop it according to that use. Is that true?
It does, but the infrastructure plan is based on compatibility and environmental issues. It has a similar set of criteria. And so if the environmental study demonstrates that it's not a use that should be allowed, then the commission would take that into account.
Okay, so you said it has a similar set of criteria, but it's going to have different information. It's going to have the information, it's going to have the information that we've heard is essential to know whether the site is stable. Is that true?
It will.
Okay, but this board is supposed to make its decision without knowing whether the site is stable.
This board can make
order.
This board, I believe, can make that decision because, again, the approval of this special exception in no way allows the developer to do the construction on those improvements. That can only come after the evaluations have been completed as part of an approved infrastructure plan, which will be approved by the commission.
Mr. Thomas, have you had any communications with FDOT regarding stormwater treatment on this property?
I've not.
Okay, that's all I have.
Thank you. Ms. Lindberg?
So before you start, members, we are at our stop time, and we would like to know if you would like to continue the meeting for an hour, if you like, more if you like.
Mr. Chair, I would suggest perhaps another hour to midnight since you've got all these folks here. But if a motion can't be developed at that time, then I think this would need to be continued. But I certainly wouldn't go any later than midnight. You know, I realize people have been here since 6 o'clock, and you've got, expert testimony and so on and so forth. But I don't think it's prudent to go to like 1 or 2 in the morning. No, sir, I do not.
Yeah, I feel like we should continue.
I'm fine going to midnight.
Okay. So we will continue until midnight and reevaluate at that time.
Okay.
No,
Sorry?
yeah.
Oh, would you?
Yeah.
Then we can take a short recess and we will return with you.
Thank you. You did a very good job presentation.
Oh yeah, I'm excited to ask some questions.
And
I appreciate. What's your name?
Ed King is my name, but
Hey, nice to meet you. I'm Soorya.
yes, I recall.
Did you get a postcard from me?
No,
Oh, you just heard about it?
but we're on a well, and there's a sinkhole not far from the house.
What is can I keep in touch with you?
Are
you comfortable with that or no?
I don't mind giving you my phone number, but I never carry it because I break them all the time. But it's 239
I've probably made questions.
220 1312.
Thank you.
And yeah, actually, I'm fairly new in the area, but
Thank you so much for coming.
You bet.
So how did you hear about it?
The Main Street paper.
That's great.
The reporter. I was hoping to be here.
So
He or she.
Yeah, Lillian is here. She's the one standing against the. Oh, she's wearing a plaid jacket. Standing under the projector. It's a girl with long hair. Yeah, she's really nice. I'm glad that worked. I appreciate you coming.
And the fellow they were trying to stifle.
Oh, my witness. Yeah.
He was doing a great job too.
Oh, okay, great. They record us. That's great. That's smart. I should have brought a protein bar. You're like, this is your day to day.
Everyone, let's take our seats, please. Okay, before we proceed, we need to kind of haphazardly did that. Let's set this in place. The stop time will be midnight, and we'd like to get a motion. If one of you would put forward a motion.
Can I do my cross first?
Give me a minute. If one of you would put forward a motion that if we are not completed at midnight, that we will continue to a date in certain in the future.
Mr. Chair, I'll make a motion that we conclude this evening at midnight. If the business at hand is not complete, that we work with the applicant and the affected parties to get an amenable date for everybody. Do you know what I'm saying? I don't know that we can get that date tonight, but that would be the spirit of my motion, sir.
Second.
Mr. Chair, after we conclude cross, the applicant is requested to approach and make a request.
Okay.
Thank you.
So, is there any public comment for this particular motion?
Thank you. For the record, my name is Christopher Hartman, and this is the third meeting that I have attempted to attend to make a public comment regarding the Terra properties. It seems like it continues to be delayed and kicked down the road, and every time that I show up here, I am cut short or told that we're doing that at a later date. And I'm getting tired of having to come back here and sit for 6 hours through these meetings to be told that I have to come back again. That's all I have to say.
Thank you. Any other public comment?
Hi, how's it going? Derek Dunlop, for the record. I'm an active cave diver and resident. I have been lucky enough to dive the Mill Creek system several times with Ken Sallet there, and help support on the dives that made that cave map that we looked at earlier with the radiolocates. In my opinion, the cave is the most spectacular natural feature in Alachua.
Sir, could we have comments on the motion, please?
I guess I might be confused on. I thought we were just talking about
the motion is to if we can't get through it at midnight, we need to continue. No worries. Anyone else, please?
Okay, so I'm not super clear on what I can or can't say. My name is Teresa Daly. I live in High Springs. I am affected by this. And it seems to me as though this is the aquifer is 100,000.
Ma'am, we're comments are for the motion on the floor to continue it if we cannot get done by midnight.
Okay, well, obviously this land is very vulnerable, and I will. Okay. Okay.
Mr. Chair, Tamara Robbins. I appreciate the fact that you are willing in the motion to extend till midnight. That's the appropriate way to go. However, to then give a condition that if there isn't a decision which by midnight that it's going to be continued to some date and time and place certain in the future that we don't know, and all these people have come together. Honestly, I have been coming to these meetings and following this project for years, and I am tired of it too. And the last September 2025 meeting, or excuse me, 2024 meeting was pulled off the agenda. The November meeting was continued, and then now here we are again. So I'm urging you to, if you need to stop at midnight, you don't need to. You can continue to 1. I sat in commission meetings until 2 in the morning when there was a big issue. I'm saying the decision needs to be made tonight. Testimony has been provided. People are here. It is costing everybody money and time and quality of life. Please make your decision tonight. Thank you.
Soorya Lindberg, comment on the motion. I've seen it in other commission meetings where they get to an end time and then you add 30 minutes or 15-minute increments. So I can request you reconsider the motion where if you need to go at midnight, maybe you need 15 more minutes, maybe you need 10. It would be unfortunate to change the whole day.
My name is Michael Getman. I live in High Springs. I drink from a well. I'm prepared to be here till dawn. I can go till it's dusk. We need to get this resolved. There has been plenty of testimony from experts that have shared very verifiable information. I don't know what the holdup is. So I have more to say when the opportunity comes. Thank you very much for all of your patience. Yeah.
Thank you. And that is kind of the point, is everybody has more to say, and it will take past midnight. And you may be able to go to dawn. I'm not. So, and our court reporter is not. So, any other further comments, please?
My name is Tim Staley. The only thing I would say is if you're going to delay the meeting, then the first thing on the agenda should be public comment.
If we're at that point, that would be.
Mr. Chair, I would just clarify for the record that, as I understand it, the court reporter needs to leave at midnight, somewhere thereabouts. I believe I heard that during the break. So, in any event, we've now lost, I don't know, almost 10 minutes on this motion. It's now 11:23. If we can maybe take things out of order and perhaps get through public comment tonight, might that be the way to go? And if that's 12:15 or something, we at least get there. And hopefully that's some sort of compromise. I don't know how late the court reporter can be here. So,
Mr. Chair, what I'd recommend is we are burning the clock, arguing about the motion. I agree with you. I would very much like to finish making the record this evening so that all the affected parties have their testimony. We are painfully close. We have cross-exam by our last affected party. If we can finish that piece, put a pin in the continuance or the extension motion, hear briefly from the applicant, I think this may resolve itself.
Very well. All right, do you have?
So, Mr. Chair, I'll withdraw the motion and simply, and I don't know, did we get a second on the motion? I thought. Okay.
I'll withdraw the second.
All right. So I will make a motion that will go till midnight and if need to be slightly past that, but understand that we won't have a court reporter here and I'll defer to legal in terms of how that would impact the record. But I do think it may not flow real well, but I do think we need to somehow get the public comment in there. And we've now got 35 minutes till midnight. So
let's rock and roll and finish our affected party cross.
Do we have a second?
Second.
Okay. All in favor? Aye.
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 Okay. My name is Soorya Lindberg. My first question is for Mr. Alfieri. I noticed in your presentation there were LiDAR maps. What were the source of those LiDAR maps?
U.S. Geological Survey.
Okay. I bring that up because the Swanee River Water Management District might have a different one that I've seen. You mentioned in the last cross with the county, you said the applicant is doing the work. Can you explain that?
I was retained to review and provide opinion based on the review. So they will be doing the testing. I will be doing reviewing.
Who exactly is doing the testing on the ground? Who's the boots on the ground?
Well, for the site visit, I will be on site, obviously, because I want to see this stuff personally. Testing, that has to be decided by the applicant. They have to have somebody qualified to do it.
Okay.
If they do not meet the criteria, then they need to keep doing more testing.
I appreciate you explaining that to someone who does not have a science degree. So I know we're tired. So as I understand, the applicant will hire someone to do the physical testing and you review the results?
They would be doing the geophysical testing and the geotechnical testing.
Do you have a vendor name that the applicant will use that you would then review?
I can offer up suggestions based on my network of consultants and professionals who do this on a day-to-day basis.
Okay. I was under the impression that you were doing the work, so thank you for clarifying. What is your payment arrangement with the city or applicant? Because I was a little confused earlier in the meeting. What portion of the work does the city pay for, and what portion does the applicant pay you as well?
The applicant doesn't pay me. I'm retained by the city.
Okay. So my next question, we might have answered a little. Will the applicant see results before they provide it to you or the city to review? What is the process?
Well, if their consultant is doing the testing, they will see it before I see it. They will have to be provided to the city and the city to me.
Okay.
They're the hub of the information for me.
Okay. So, Mr. Chair, we're learning that the applicant is in charge of who does this testing, and the city retained a person to review it. Okay. This is not comment. These are questions. Thank you, Mr. Alfieri. That's a big concern that they get to pick, and I thought the city got to pick. Okay.
Just to clarify, there be coordination. So, in other words, the applicant has to hire someone who's, if you read the cover letter that was provided by staff to the applicant, and I'm not going to remember it verbatim, but basically it has to be a licensed professional geologist competent in geophysics and geologic testing. And Mr. Alfieri would have to approve that.
Okay. Next questions are for Mr. Thomas. Do you know when the FDOT comp plan amendment happened? Do you have the date?
I would have to actually look that up, but I think it was somewhere in the 2010 to 15 range.
Okay. I'm sorry, crowd. I had all my notes and then we had a break. Throughout your presentation, it was a lot of text that this is the policy and it met it. Where is the proof and backup material for the board to review, for example, that it minimizes environmental impact? To me, it's a statement. What are you relying it on as a planner, as other experts, to say every condition is met? Because you did not sort your sizes, and we do.
The opinion was based on what was provided by the applicant in their application materials.
So the applicant gave you what they wanted you to see, and you reviewed it. It sounds like you've seen lots of testimony where other experts have brought up important stuff. Okay, so the applicant gave you information and you reviewed it. Okay, that's something new in all my days here I haven't heard before. Okay, so you say all 3 terras are connected via the infrastructure plan. Is the infrastructure plan connected to the special exception permit?
To clarify, what I said was I agreed with the interdependence of the different portions of the Terra projects. The special exception is dependent upon the Terra April infrastructure plan, and then the Terra Phoenicia infrastructure plan is in turn dependent, at least in some part, on the Terra April infrastructure plan.
Okay. You also said a conceptual site plan. There's been former city staff who said that's not acceptable. Has policy changed about that in the last 2 years?
I don't have any indication from former staff that that was not acceptable.
Okay.
Did you present? If I missed evidence that you presented in your presentation, I apologize. But based on what was in the record, that is what we're going on to prepare for the meeting. It was deemed acceptable.
Okay. Mr. Chair, I've come through multiple thousands of pages of public record, and there are letters where staff says that, and it was not in the documents. All right. And do we know how heavy a 6-acre pond will be?
That ventures into the realm of engineering.
Okay.
And I'm not qualified to comment on that.
Okay, thank you. So we learned that they're interdependent. Okay. My next question is for the applicant. Oh, do you want to come up to the microphone? Oh, okay. Okay, sure. You mentioned 18 public hearings. Were these all for Terra April, or was it for other terras as well? Is there a list you could provide the city?
Those hearings were all related to this parcel.
Okay. Is it the Terra April parcel? You shrugged. I don't know what that means.
Yes, the Terra April parcel.
Okay. Yes. It was quoted that no adverse impacts based on the Suwannee River Water Management District ERP. Does the applicant know that the Water Management District is not a designating body for the city?
The Water Management District is a body that does stormwater and environmental resource permit approvals and review.
Okay. Mr. Chair, if you read the approval letter in the Suwannee River bylaws, they say they are not a designating body for the city. For example, if they say yes, it doesn't mean an automatic yes for anyone else. That's my understanding of reading the approval letter. Is there a signed and sealed site plan by a licensed engineer?
That's not a requirement for the special exception. There are infrastructure plans that are not under review tonight that were signed and sealed by a professional engineer, but that's not what the topic is this evening.
Sure. And quick follow-up, was an infrastructure plan submitted to the city for review?
Yes.
Mr. Chair, in November 2025, I made a public record request for a Terra April infrastructure plan, and I got a result that said there was no conclusive records, so I did not get anything. That is a concern. For those meetings you had, those 18 meetings, was it a concern that no one attended it, considering how interested the community is?
Those hearings were in front of the Planning and Zoning Board and City Commission, so there were many people present. The decision-making bodies by the city were here, and they considered all the evidence at the time and made their decisions.
I'm referring to the neighborhood meetings where 0 people showed up. Was that a concern that no one showed up from the neighborhood?
Typically, in my experience, when no one shows up and it was properly noticed, that there are no concerns noted.
Okay. Just 2 more questions, Mr. Chair. Would the applicant be open to a third party doing independent testing on their property? Not me. You don't want me to dig a hole. If there is the public sponsors companies similar to Apex or who the vendor picks, would the applicant be open to an independent testing considering how significant this is to our community?
So I would defer to our counsel to answer that question. Thank you.
The applicant would not be open to a third party unless, of course, the board, the Planning and Zoning Board, were to provide a basis for. We already have, of course, a third party with regard to the city having hired an outside consultant, serves as a third party, and we'll be hiring appropriate folks to do the actual work on the ground, as he discussed. So the suggestion, I guess, is that you don't trust the city, you don't trust Alfieri, you don't trust the geotag, and so a third.
That's incorrect. Can the record state I do not agree with her assumptions? We have never spoken before this meeting and everything is public.
Okay, good. So you do trust everyone involved in the process.
Mr. Chair, my trust is not the question here. My question is, will they allow a third party to do independent testing aside from the vendor that they cherry pick?
Okay, so I'm not going to go back and forth, but we
Ladies
have a
and gentlemen,
process in
order.
place.
Excuse me.
Sorry.
Order in the crowd. Please do not outburst. You're delaying the proceedings. Please keep your comments to yourself until you're at the podium at the appropriate time.
We will comply with the conditions from the Planning and Zoning Board, from the City Commission at the infrastructure plan stage. Thank you.
Thank you. Great news. If you make a condition that the applicant allow a third party to pick the vendor to do their independent testing, they don't spend $1. They just allow someone on the property. I don't know who that would be. Maybe another affected party would want to do that. There is a concern as this member of the public that they get to pick the people that dig in the ground. Last question. Has the applicant spoken to FDOT in the last 6 months?
Yes, we have.
Can you describe the extent of that? And can you provide, first question, can you provide the extent of that conversation? And second, can you provide that correspondence with the city for public record?
Mr. Reyes, could you come up and explain your conversations that you've had with FDOT? As far as correspondence, we had conversations which you asked, and so he has the conversations and he'll be able to provide documentation. It may not be tonight. Come in, go ahead, Sergio. Introduce yourself, please. Sergio Reyes is the engineer, stormwater engineer for the project, amongst other things.
Sergio Reyes, professional engineer since 92. We contact, actually the first contact that we had with DOT was before even the comp plan it went into effect. That would be the conversation is 6 months. We review all the permits from DOT. Actually, I put a couple of calls to DOT. Doug Dykos, engineer, he never respond to my calls, never respond to my emails. But leave it in that point. Any other question?
Thank you very much. That concludes it. I'd also like to state for the record, I do not appreciate the applicant being aggressive with a member of the public who is an affected party. I am not being paid to be here by the hour. This is my life. This is my water. When you have a hurricane, Mr. Chair, what's the first thing that goes away? Water. I do not appreciate it, and thank you for taking my time. My comments, and I appreciate everyone's time. If anyone wants to speak really quickly in public comment, it would really be great to end this by 11:59.
Ma'am, please. Mr. Chair, The applicant is requested to make a request at this point.
Mr. Chair, if I can just add real quickly, the text amendment for the record was effective December 9th of 2024 in the comp plan. Thank you.
Ms. Judd, did you mean 2021 for that comp plan? Is it 2024? Comp plan
Mr. Chair,
amendment?
yeah, I'm talking about the text amendment to the comp plan. I just had that page with me. And I can only tell you at the bottom, the footer says December 9th, 2024. The text amendment.
Should be 21.
Well, that's what the page says out of the comp plan, so I don't know. Okay.
Understood. So,
Mr. Chair, just to clarification, that's the last adopted. That's the date that the comprehensive plan in that form was adopted, not when that site specific element was adopted.
Thank you for the clarification.
thank you. We wanted to, at this point, because we know we've been talking about the timeframes, but more importantly, we've heard from the board members quite a bit about the fact that the infrastructure plan will go only before the city commission, which is typical, right? The only reason that the questions being posed here tonight is because of a special exception. But typically, if you're doing stormwater infrastructure and anything supporting that, you'd be going before the city commission. You would not come before this board. But we understand the concerns as raised by you and by the public. And so we are proposing or offering that we go ahead and prepare that work in a timely manner to be able to submit it to this body. Clearly, it will have to go to the city commission as is required. But this body's, I think what I'm hearing is you want to see it. You don't want just the city commission to see it. You want to see it. You want to consider it. And so we are proposing that we continue the proceeding to allow that geotech work to take place in a way that will come back to you, to the members of the public who have indicated an interest, so you can see that we'll still have to go before the city commission. We still have to do infrastructure plans. We don't have an option. That's a requirement. But at least it would give you an opportunity, because as you asked, and I think Mr. Thomas may have responded, there isn't an avenue in the process, the way your code works, that would bring that to you. So it would be a continuance to allow that work to happen and to come back to finish this proceeding with that data analysis in the record, and then to move forward if we receive an approval to the city commission infrastructure plan design based on that work. Of course, Mr. Alfieri's participation would be as we had initially indicated. And as you heard earlier, we haven't worked through the details of the conditions if we were to get an approval, but we said we will comply. We will do the work. So now it's just a matter of doing the work. Now, one thing I would say is the special exception is for April. We have to do the work for the infrastructure plans for Phoenicia and for West, construction plans for West before staff. The piece that would come back here would be the April work for the April special exception, is what I would assume.
Yeah, but the hydrogeologic work that Mr. Alfieri is recommending and that staff concurs with would study the area of interest. So
Correct.
it would cover your three pending, that area would cover the real estate that those applications address.
With the conditions having been drafted to say you can't schedule the infrastructure plans until those materials are ready for each thing, but for this board and the geotech, like what we need to be prepared to offer into the record for this proceeding, I would assume it would be the portion tied to April.
Right, but you're going to have to show the whole study for the entire area, or you're going to be repeating, the same testimony this evening.
Okay, so I just confirm with the client real quickly. I think the work, as we had intended, will ultimately cover all pieces.
Right.
But to move forward and to give this board what it wanted, we were wanting to do the April piece. And again, I don't, that may not even be a possible thing based on how geotech actually works and, all that. But the offer would be to do the work to allow this board to see the April piece. The entirety of the April piece, not just a portion.
We may be talking past each other, but just to kind of boil it down to simple terms, the city's going to require the work to be done that's been described. And the issue here tonight is, when does it get done? And so I'm hearing the board express strong interest in having that work done before they take a vote on the special exception. Notwithstanding the fact that maybe you focus on the area of subsurface that's beneath Terra April, but understanding also from what I'm hearing from the experts, everybody, that there's potential, interrelationships that need to be either explored or debunked.
Right.
And so I think that the answer will suggest itself, I guess, is what I'm saying.
I think we're on the same page with regard to the work. I guess the question is just still about what to this board versus the work to the city commission, and whether there is any distinction between the two. We're coming back to this board with all the data on Venetia and April and West and all of these things, or are we coming back to this board with the April piece, which is what we're proposing?
I believe this board only votes on the special exception.
We have the special exception piece in front of us at this point, but I am of the opinion that I would like to see the entire study for the entire property. Members?
That's what I'm hearing. So if that's amenable, of course, then you tailor your presentation back here according to what's required for the application. But the board is going to want to see the whole study.
Mr. Chair, and listening to the applicant, so am I hearing that the applicant is willing to do the infrastructure plan, which would, be for all the basins, right? All the 3 basins there, and
no, we're talking about the hydrogeologic work.
Okay, but
there's still going to be 3,
right? But the reason I'm asking about the infrastructure plan is, and then also the geotechnical work, which would be for the whole area. So what I'm trying to clarify is the applicant saying that they'll do the infrastructure plan, which normally doesn't come to the plan board, and all the geotechnical work to come to the plan board as part of its decision-making process. No. So then what are we saying?
You still have jurisdiction over the special exception, but the cart before the horse question,
Right.
that's all we're trying to deal with right here.
Right. I understand that. And that's why these 2 pieces, I think, are the cart before the horse.
So you're going to get what I'm hearing is you're about to get a look at the entire study, because it wouldn't make any sense to go out 3 times and for somebody to pay mobilization charges and write 3 reports and pay Michael to review 3 reports. So you want to do it one time, etc. But they're only going to come back to you for a vote on the special exception, because that's what your code allows, and then they go to city commission on the infrastructure plans.
So I think I understand what you're saying, but what my question is, so then what I heard the applicant say is that and I understand what the process is, but that I thought I heard that they would be willing to have the infrastructure plan come here first, obviously knowing that it has to be approved by the commission, but that's not what we're saying.
No.
Okay.
They didn't say that.
All right.
I think they're conferring, so we'll just need to give 10 seconds.
We are, per the client consultation with the client, the proposal is to do the work for April, not just this portion of April, but all of April, and to bring that back to the board as a part of the special exception.
And
I'm sorry. When you say April, the geological study is for the entire property.
The 58.32 acres
Right.
of April.
So we would see that entire study.
Yes.
Okay. And then you'll bring back this special use permit to us once that study is complete.
Correct.
58 acres is just Terra April. Staff is recommending that the Phoenicia and Terra West properties be studied all at the same time. So because from what we hear from the experts, this is a geologic system, doesn't observe application boundaries.
Correct. So we'll see the entire property study.
I need Mr. Thomas to put his opinion on record to you.
So, Mr. Chair, the letter that I provided to the applicant on Monday, or Tuesday rather, the 6th, basically requires that the study be conducted that would cover the entirety of the project area. So Terra April, Terra Phoenicia, and Terra Forest West, at least under phase 1. And so, again, especially based on the testimony from our expert, but also other experts, indicating the interconnectivity of the system and the potential interconnectivity, as Boyce stated, the geology doesn't recognize property lines or project lines and things. And so I think it would be in the best interest of the city to be able to move these forward, to have the entirety of the study available for our expert to review at one time, rather than try to spread it out parcel or project by project.
I think where April seems to be the boundary that we can ultimately, per what I passed out earlier, the subsections of the 9, I think condition 9, the work has to be done for the infrastructure plans, and it will be done. The issue is just moving forward with something to come back to you so we can know if we will have a special use permit to even bother moving beyond that, right? So we're trying to get to the point where we say we're here for the special use and here's the data. We know that the entirety of all the parcels, all the pieces sitting out there for the city commission will have to be looked at. But just as far as being able to move forward, respond to this board's need to see this, because again, the city commission will see all. The proposal is April. Mr. Thomas, we got that.
So we don't agree on the scope of the study that would be coming back to this board prior to your vote on the special exception. So we then resume the hearing that we have before us, unless the board has a different motion in mind.
Members, what are your thoughts? I personally want to see the entire study.
For myself, I can't, I'm just being very candid, it's open meeting. I can't vote to move forward with a special exception without having the complete picture. So for me, if I had to do a motion tonight, it would be deny, and that would be the end of it. So, you know what I'm saying? It's up to the applicant if they want to withdraw. You know what I'm saying? I'm just trying to think out loud is what I'm saying. I don't know if the applicant wants to withdraw the special exception, in which case it's done, okay? And you can go back to the drawing board or what. But the application as presented before this evening, I can't vote approval for. So I know we're getting close to the hour and we're trying to get some ending spot, but that's my thought. Thank you.
And Mr. Chair, you have one other option that Mr. Thomas just reminded me of. You could vote to refer this back to staff or further evaluate. Hold on. Why is that funny?
Ladies and gentlemen, let us continue this.
To refer this back to staff for further evaluation, and before we come back to this board, you know, we would have additional dialogue concerning the study, or you can proceed this evening.
What's everybody think? Because again, I'll say it again. I don't want to approve this without seeing the entire study.
I mean, I would say I'm in agreement. I think, you know, my questions were to that point earlier, you know, why one comes after the other. You know, I think it makes more sense to review that information prior to approving.
Yeah, I agree. I mean, I feel like with the significant environmental features, the geologic features that we talked about, I think there was some mention from DOT about reducing the base flow to the wetlands with that intercepting pond, without seeing how these ponds are connected to the Terra Phoenicia and the Terra West. If they are, and if there's compensatory storage being provided on this parcel that could be provided on that very large Terra Phoenician parcel, why does it have to happen there? And so, and I think the geological study would support or not what we're trying to do here. So I feel like we need more information from an environmental standpoint.
Mr. Chair, we do need to finish the quasi-judicial hearing, and we're at the point of public comment, not affected parties or the applicant, but public comments. We need to take that, do rebuttal, and go to conclusions before it comes to the board for deliberation and vote. Okay. There's no motion on the floor.
But they got to speak, so can I speak as an affected party? It'll take 9 seconds. Mr. Chair, can I speak for 9 seconds?
Please make it quick.
As an affected party and as someone who recognizes a lot of people here, if you make a motion to deny, I cannot imagine how much public comment you get about it. People might not comment at all.
Thank you.
So we do want to be mindful of all parties' due process rights. And so we don't want to create an atmosphere where someone feels intimidated to come to the podium. So, Mr. Chair, I know you've been doing a great job at reminding the crowd of that this evening, but I want to add my 2 cents. So we're at public comment at this point.
But we haven't made a motion yet.
We don't,
We'll make
according
the
to your
motion
code. Yeah,
after
we're in a
public comment.
Yeah, quasi-judicial. We do public comment, then rebuttal from the affected parties, the applicant, and city staff, and then we move to conclusion, and then deliberation, continuance, or vote. I'm going by your code.
Sounds like we have
Public comment.
a lot to get through. At this point in time, I don't think we can get through it in a few minutes. So if we would like to continue this.
Do we know how many persons have indicated they want to speak in public comment?
Show of hands. It sounds like we got a lot of people that want to speak. So I think it would be best to continue this to a time when all of you can get your opportunity to come and speak. Members?
I think for me, I hate to put our court reporter on but I mean, as I understand it, she has to leave at midnight. And as far as I know, these proceedings require a court reporter. So, I don't know if another 20 minutes would make a difference. But for me, I do not feel comfortable proceeding without a court reporter taking down all of the testimony, whether it's public comments, staff reports, board comments, questions. I think that would be ill-advised. So, at any rate.
Do we have a motion?
Can I just ask a question? So if we go, so after public comment, if we're talking about potentially needing them to come back with the additional research, how does that work in terms of the procedurally how that works? I mean, what are we trying?
Or back on the other idea of continuing the hearing for the purpose of allowing them 3 to 6 months to do the geologic testing. We hit the ditch because we don't agree here tonight on whether just Terra April's real estate would be looked at or the entirety of the Phoenicia, April, and West. So that kind of died here tonight. So you're looking at continuing this meeting for purposes of finishing your quasi-judicial hearing, and then at the end of which you would deliberate, put a motion on the floor, deliberate, and vote. That's your next.
So if we have to go in that order, if we have to vote tonight in that regard, we're required to do the public comment first.
Correct. Public comment,
Okay.
rebuttal, conclusions by the parties. Yes, ma'am.
And so would that be the next regularly scheduled planning and zoning board meeting is when?
No, I'm going to defer to Mr. Walker. I'm not familiar with your procedure on that.
And you could do like you did this evening, if you have a few items that will be fairly quick, advance those on the calendar and then go to this. So that's very doable.
I just don't want to leave it hanging for too long. I mean, we've heard a lot of information tonight that was valuable to make an assessment. And I just don't want to wait too long. Don't want to kick the can too much further down the road.
So, Mr. Chair, if we, obviously, we can't continue without a court reporter. So if the next item, when this comes before us again, is on public comment, my only consideration or understanding would be that we're not entering additional data, right? We haven't gotten that far. We've kind of bounced around a little bit, given some indication to the applicant what some of the pending questions are from the board. But we would start at public comment with the record as it stands now.
Public comment would be based on the record now. Then you would go to rebuttal, and the affected parties, the applicant or the city, could rebut the entirety of the record tonight, and that could include answers to questions that were raised or assertions made. That's perfectly legitimate. But it does not reopen the record for a whole new PowerPoint from an expert, for example.
Okay, so just to clarify, in other words, if this were the next meeting, we would start immediately with public comment. There would be no additional, stuff provided. And I'm just trying to frame this so it doesn't sound like we're going on and on and on.
Right.
And at what point does the window close on the data? So as I understand it, the applicant would hold firm with their application. The staff report would be as it is, and we would simply hear public comment, go through the end of the process, and then make a motion. And
No, you have public comment, then you have rebuttal by the applicant, the affected parties. So you would hear from the applicant, the county, the Speleological Society.
okay,
That would be rebuttal to any of the testimony and cross-examination that
Okay.
occurred tonight. After that, the applicant, the city staff, and the affected parties could offer you a concluding statement. And that's definitely not new evidence. That's just summing it up for you to give you a takeaway. So rebuttal, when you rebut, you could have a rebuttal exhibit, but we're not encouraging, you really want to rebut what's been discussed already in cross. You don't want to come in with a whole new presentation. That would be
Okay.
disfavored.
Mr. Chair, when is the next regularly scheduled plan board meeting?
I'm gonna defer to Mr. Thomas on that.
It would be February 9th.
So we either do February 9th or we schedule some sort of special plan
meeting.
board meeting 2 weeks from tonight or something. And I, I don't know the availability of the applicant. And so I would just kind of throw that out for discussion and get some feedback, I guess.
So you would be proposing Tuesday, January 27th.
Does it have to be 2 weeks?
That was just a suggestion from your colleague.
Could it be next week?
No, we'd have to public advertise it, so we need to have it out for it.
Well, if you
Minimum.
continue to a time
It's that
certain,
date certain, you don't have to.
No.
Mr. Walker, if we continue to a time certain 1 week from tonight, is that permissible without re-advertising?
Mr. Chair, Carson J. Crockett, Principal Planner. I just wanted to clarify, the next regularly scheduled Planning and Zoning Board meeting is February 10th, not the 9th. Thank you.
No.
Okay. The consensus of staff is you could continue for 1 week, but you would have to do it to a date and time certain. You would not have to re-advertise under your rules.
So that would be January 27th at 6 p.m. I don't have a calendar in front of me.
20th at 6 p.m.
I'm good. I'm good with that.
That works for me.
January 20th. Do we have any trial conflicts with any of the council for the affected parties or the applicant?
That works for us. Thank you.
Ms. Graham, you're saying it works for you and the county attorney. I think Sylvia, Ms. Lindberg works for you.
Mr. Chair, you asked about the 27th?
20th.
The 20th? No, I think we can do the 20th. Not February 10th, but we can do the 20th.
Okay, so based on a consensus, I move that this special exception be moved to January 20th at 6 p.m. In this building, and that we start with public comment at 6 p.m.
Second.
It's been moved and second. Do we have any public comment on this?
My name is John Havlick. I live here in downtown Alachua. And the only thing I would ask is that we have accommodations for people in case the space fills up like it did earlier this evening. Thank you.
Thank you. Any further public comment?
Nathan Warner, it's been a pleasure to be here and listen to all of the testimonies from everyone. I think we could forgo the next meeting if you guys just did what you know is right in your hearts.
Any further comments? Do we need to do a roll call vote on this or? Nope. So all in favor, aye?
Aye.
Aye.
We have to.
There are a couple of items.
She's outdone. Not recommended, but I do have a driver's assist on my car.
So, no, we are.
I don't. I
I
wasn't
find
there.
mine.
Oh, I was there the other night.
Not the 18th. Have to reschedule. So what we'll need a motion to approve the November 15th meeting in another meeting in the future.
Mr. Chair, that's correct. The November 18th, 2025 minutes will need to be deferred to the next meeting. But I would then move to approve, and this doesn't need to be for the court reporter. I would then move to approve the meeting minutes from December 9th. Or no, one of you guys needs to make that motion.
Move to approve the meeting minutes from December 9th.
Okay, I'll second that.
All in favor?
Aye.
Aye.
Can I get a
motion to adjourn?
I have a second?
Second.
All in favor?
Aye.
Aye. This meeting is done.
What's left of it? It's morning now. Morning. Might as well get the work started now.